All rise. The President and judges of the Supreme Court of Justice.
Call the matter.
CCJ Appeal number CV2 of 2005, the Attorney General of Barbados, the Superintendent of Prison, the Chief Marshal versus Jeffrey Joseph, Lennox, Ricardo, Boyce.
Sir, Mr. Ford, would you like to resume?
Your Honors, I took your advice late yesterday and reflected upon the amendment made to Section 78 of the Constitution. It was my submission then, and it remains now, that no argument was raised in the courts below in relation to the amendment to paragraph subsection 6. Notwithstanding that, my submission, Your Honors, on the amendments are as follows. I find it is a useful rule. In construing any document to read it as a whole and not to dissect it. And with that approach, I will take you, Your Honors, to the Section 78, which is found at paragraph 42 of the judgment of the Court of Appeal, paragraph 42 of the judgment. It sets out paragraph, Section 78 in detail. But subsection 1, the Governor General may, in Her Majesty's name and on Her Majesty's behalf, grant to any person convicted of any offense against the law of Barbados a pardon, either free or subject to lawful conditions. The first observation I make about that paragraph is that it relates to any offense committed in Barbados, be it a traffic offense or be it treason. That's the first observation. In relation to any of those offenses, the Governor General has some clemency. Subsection 2, the old subsection 2, provides that the exercise of the Governor General should be in accordance with the advice of the Privy Council. Subsection 3 is an interesting one. Subsection 3 provides that where a person has been sentenced to death, the Governor General shall cause a written report of the case from the trial judge, together with such information derived from the record of the case, or elsewhere as the Governor General may require to be forwarded to the Privy Council. And the words, or elsewhere as the Governor General may require, in my view, are instructed. It is not as elsewhere as the courts would desire. It is what the Governor General desires that should be forwarded to the Privy Council. He may desire nothing to be so submitted. And if he desires nothing to be so submitted, all that is required of the Privy Council is to consider those matters which are specifically mentioned therein. Subsection 4, the original subsection, the power requiring information conferred upon the Governor General by subsection 3, and again we're referring to that particular information shall be exercised by him on the recommendation of the Privy Council. And then it gives another caveat. The first subsection, in my view, the amendment, in my view, merely codifies the practice of the Privy Council as it was before. The original practice was not written, and what it does, it codifies that you may submit it in writing and you don't have a right, an oral right to respond. Subsection 6. There is a precondition to subsection 6. What subsection 6 does? Subsection 6 answers the question of time limits for instructions, which did not originate in Lewis, but they originated in Patten Morgan. So if you were to issue an instruction, as was issued in Thomas and Baptiste, there must be authority to issue it. And what subsection 6 does is that it gives the Governor General the ammunition, the authority to issue an instruction. So if he issues an instruction, here is where it happens. If the Governor General issues an instruction in relation to the petition to international bodies, as was done in Thomas and Baptiste, it naturally follows that the information which he required under subsection 3 was information from a particular body. The fact that he placed a time limit in relation to a particular body from the outside is clearly suggestive that he required that information under subsection 3. And in my respectful submission, the corollary is also true. If he fails to set a time limit, he doesn't want to receive it. If he does not set a time limit, he's saying, I don't want to hear from you. That's the corollary of it. And in the instant case, he set no time limit in relation to the petition from those international bodies as was set in Thomas and Baptiste. So the natural inference, he did not want to hear from them. My further submission is that the discussion in relation to the amendment of the Constitution comes under issue number 2. If you will go to paragraph 40.
But before you go to argument number 2, if the Governor General has an unfettered discretion as to what, if anything, other than the judge's report, he puts before the BPC, then why was it necessary to make a constitutional amendment in order to give him the power to put a time limit on the provision of material which he was free not to require?
He was free not to require it, and he was also free to require it. He was free not to require and free to acquire.
Yeah, but so presumably, if he was free to require it, he would be free to require it subject to time limits without the assistance of a constitutional amendment, wouldn't he?
My response to that is really answering. In so doing, they were answering the complaint in Pratt and Morgan. If it were otherwise, and there was no time limit, one could extend the process of 10, 15, 20 years. But what we are saying, that subsection authorizes the instruction which was given in Thomas and Baptiste to limit the time limit in relation to petitions to international or other bodies.
The instruction in Thomas and Baptiste was given by the Attorney General, not by anyone connected with the Mercy Committee.
My response to that, the fact that it was given by anyone not connected to the Mercy Committee, does not prevent the Constitution of Barbados from saying who should give it. The Constitution could have said it could be given by the Minister of Finance, the Attorney General, but they have directed, as the supreme law, who should give that direction in time limit.
The question is not whether the Barbados Parliament was prevented from making this provision. The question is why was it necessary?
It was necessary. It was necessary because of the response to Pratt and Morgan, whereby there was some confusion. The international bodies were delaying their responses to various petitions, and the state had to take some measure to protect itself. In fact, Thomas and Baptiste makes that point, that a state which wishes to retain the death penalty must act swiftly and set its own procedures. And all we are doing, we are acting in accordance to the advice and coming out of the Pratt and Morgan and those other cases, that if you wish to retain the death penalty, you must act swiftly.
But Mr. Ford, in your words, the state was protecting itself because perhaps the state recognized the right of the persons to go to the international bodies?
No, not at all.
So why was it necessary to protect itself in this
Those
manner?
are two separate and distinct issues. And in fact, that's what I've said before. In terms of the rights to apply to an international body, that arises out of the Constitution itself. If the Constitution makes no provision, the entering into a treaty cannot give you that right to apply.
No, I know that. You've said that before. I just didn't quite understand. You used the term protecting itself, and I couldn't quite understand why there was a need to protect itself if there is no right to go to the international body.
Let's put it away. The legislation may be prospective. At some point in time, a treaty may be ratified and incorporated into the domestic law, which gives that right. So the act itself may be prospective.
But you think it's sheer coincidence that this amendment was made in 2001, and that in September 2000, the decision in Lewis was given? Is that just a coincidence?
I do not know, but let's assume that it is not coincident. It is not an acceptance that it could be passed for an avoidance of doubt.
What I thought you might have argued, although I don't know whether I haven't really thought about it, may not have any merit. But there's a point I raised yesterday, and that is whether the amendment in 2001 can really affect the interpretation of the Constitution as it stood before then.
If it can affect
the interpretation of the Constitution as it was prior to the amendment.
Prior to the amendment, there was no constitutional right. Prior to the amendment, there was no constitutional right to apply to a human rights body.
Yes, right.
And this particular provision does not expressly grant that right. It is interesting to note that the courts, in holding that such a right existed under issue 1, never referred to the amendment. The amendment is only referred to at paragraph 42, and that's the point I'm making. Paragraph 42 deals with the second issue. So what the court is saying, this amendment relates only to the issue as whether the prerogative of mercy was determined in a fair and in a manner in conformity with the principles of natural justice. It is found, and not by accident, and not by coincidence, it is found intentionally so under that particular section. It is never raised, the judge never raises it as a reason for his decision of incorporating. He doesn't. And the answer, and I can respond by that saying, since there is no cross appeal, one could assume that the respondents are affirming the decision on the reasons so given. If there was a cross appeal, they can say, I agree with the decision, but for other reasons. And that has not been so alleged. So we are bound by, the respondents are bound by the reasons given. They are seeking to affirm the decision by the reasons given. And the amendment is given in relation to.
Well, that would not be a cross appeal. It would be a respondent's notice that
That's
they
right.
were supporting the decision on a different ground.
That's right. And I would have had to have notice thereof so that I could respond accordingly. That's the purpose of the notice, not to take me by surprise. In the absence of that notice, I assume.
I'm still curious about the Hansard.
I am told there's copy of the Hansard is available.
Do you have it? Do you have it?
Mr. Ford, you just said prior to the amendment, there was no right to go to the human rights body.
Prior to the amendment, there was no constitutional right, express right, to petition an international body.
And after the amendment?
After the amendment, my respectful submission is there is still no.
Just hold it a minute.
There is
Hold it a
still
minute.
no express right.
Give it back. That's not
Subsection 6.
Just a minute. Just a minute.
No,
Don't distribute it.
Let's go.
Do you have any objection to looking at the Hansard?
None whatsoever.
Thank you. Okay, well, we can have it now.
Thank you.
Thank you.
You-
Yes, go ahead.
The point I was made is that prior to the amendment, there was no express right. And likewise, subsection 6 does not give an express right. Subsection 6. What triggers subsection 6 is the time limit. If no time limit is set, then you don't have a right to apply to that body. Because the subsection 6 relates to information which is required in subsection 3. If the Governor General requires the information.
But, Mr. Ford, if you had accepted the suggestion that Barbados was bound, in effect, by the decision in Lewis, then you would be able to argue that this amendment was made on that footing, and therefore, if it turns out that Lewis is held by us to be wrong and is not to be followed in Barbados, then the amendment was simply made on a wrong premise.
I think my submission is.
How does that appeal to you?
No.
No?
It would appeal. It appeals to me, but it's not my real. My submission is that the amendment is based on a response to Pratt and Morgan. What I'm saying that the concept of petitioning international bodies did not originate with Lewis. It originated with Pratt and Morgan. So let's put it this way: when Trinidad made its instructions in Thomas and Baptiste, those instructions were made in response to Pratt and Morgan. They were not made in response to Lewis. And all we are saying is that the instructions which could be given under subsection 6, although they may be applicable to Lewis, they are also applicable to Pratt and Morgan. Let's put it that way. Although they may be applicable to Lewis, they are also applicable to Pratt and Morgan. So I'm not negating the fact, I'm not suggesting that they may not be applicable to Lewis, but my submission is that the driving force would have been Pratt. And Lewis might have been a consideration, an ancillary.
But how is it possible that that has anything to do with Pratt and Morgan? They also amended Section 15 of the Constitution, which tried to neutralize that jurisprudence. So
Section 15, they amended Section 15
of the Constitution.
And that was in response to Pratt and Morgan.
Yes. So they said, well, however long it takes, can never make the death penalty inhuman.
Yeah,
So
right.
if you put that in your Constitution, why you have to put time limits?
Because we are dealing with two different sections. We are dealing with two different sections and two different issues. One is inhumane treatment, and one is the exercise of the prerogative of mercy. There are two separate sections. The breach of those sections are so far apart that they give different relief. A breach of Section 15 gives relief under Section 24. A breach of Section 78 does not give you such a relief. So they're separate, distinct and miles apart.
Mr. Ford, even if we accept that subsection 6 has nothing to do with the Lewis case, on a clear reading of it, it seems to recognize that convicted murderers do have a legitimate expectation of being allowed to petition the Inter-American Human Rights Commission. And it's for the very reason they have that legitimate expectation that it's necessary to be able to give adequate reasonable notice that produces the requisite procedural fairness. And the Governor General, under subsection 6, is expressly given the right to put a time limit so that these legitimate expectations cease to be legitimate expectations. Isn't that another way of looking at subsection 6?
I take the point in relation to it. I take the point that it does not create a right. I totally agree with you. It's a legitimate expectation as opposed to a right. It does not create a right for a party to apply. What it gives the party is a legitimate expectation. And that's the point. But the caveat to that is the parties in this case have never argued legitimate expectation. They argued rights. So I concede, and I will support Your Honor on that one, that the clear reading is that it creates a legitimate expectation, but a legitimate expectation is not a right. So there is no right. And the argument of legitimate expectation was never advanced by the respondents. They stood on a firm right. They did not cast their case in the alternative. In the event that I'm wrong on a right, there was a legitimate expectation.
But are you suggesting that as the ultimate court trying to clarify this area, we should turn a blind eye to the whole of this doctrine in producing our judgment, merely because it's not raised in the respondent's case?
Oh, it's not raised in the respondent's case. It's not part of it was not raised in the courts below, and it would be difficult to argue it now, to go back and to read on a legitimate expectation. My understanding of an appeal is done on a record. I know what I'm here for. If their case was legitimate expectation, if it was not legitimate expectation, before the court at first instance and before the Court of Appeal, it would be strange for you to come to defend a legitimate expectation. And there are several cases which suggest, Fisher and the others, that sometimes there may be a difficult course to carry to a legitimate expectation. The ratification, there are cases which suggest that the ratification may not be enough. But the argument is, I take the point that at the highest, the 6 creates a legitimate expectation, but it does not create a right.
Mr. Ford, I'm looking at the Hansard on page 3, I think the last paragraph in the Attorney General's address to Parliament.
What's the page?
3, last paragraph, beginning, Mr. Speaker, what will apply to them in the bill is a section in relation to the amendment of section 78, subsection 6 of the Constitution. Since they have not yet petitioned an international human rights body, when that section, as it does, empowers the Governor General in accordance with the advice of the Privy Council to set prescribed time limits within which they must petition the international human rights bodies and within which the Privy Council is entitled to wait for a report, that section would apply to them. Because when this suggests them, you were suggesting that it doesn't necessarily mean the international human rights bodies, but this seems to have been the whole intent.
Section 6?
And 6, subsection 6.
No, subsection 6, if you read subsection 6, it says may consult any person or body of persons, and that is not limited to human rights. That could be the National Union of Seamen in France.
I know, but what I'm saying, in answer, the Learned Attorney General seems to have had that focus on international human rights.
And my response to that, the view of the Learned Attorney General in Parliament is not the law. The view of the of course, the Learned Attorney General can have any view on a particular matter when the bill is discussed. The courts can construe it and construe it differently. That's my response. The view of a member of Parliament in the passage of a bill is not directly, it's not the controlling factor in construing that particular bill. It is a consideration. If the words are clear and unambiguous, whatever that minister said in Parliament is totally immaterial.
But we were looking at the answer, I assume, to understand what was the thinking behind 6.
And my response to that, we only look to thinking if there's ambiguity.
But is there a problem as to whether the amendment was based on what happened in Neville Lewis and the Attorney General, or whether it was simply based on Pratt and Morgan? And I think that is what we're trying to resolve. So that when you look at page 7 of Hansen, you see again it says, Mr. Speaker, we feel that a state cannot be held to ransom by an international process over which it has no control, if that process is unduly long. And then it continues, hence, section 78(6) so properly empowers the Governor General, acting in accordance with the advice from the Privy Council, to have, through instrument on the public seal, a set of time limits prescribed within which both petitions must take place, and the period of time under which they are under no obligation to continue to wait. And she continues, the same judicial committee decisions speak to the inordinate length of time that many of these human rights bodies take to complete matters. I would thought that was pretty conclusive as to the context of the amendment.
It appears that it refers to both Pratt and Morgan and to Lewis, but to suggest that it predominantly refers to Lewis, I think is totally inaccurate. There is no proportionality settled in the debate as to where it goes.
But if you go again on the same page 7, the second paragraph in column 1 does not deliberately and precisely refer to Neville Lewis and Attorney General. That's what it's.
Yes, Your Honor, but there are specific. There are also statements which refers to Pratt and Morgan.
Yes.
And Pratt and Morgan, and Pratt and Morgan, the time limits in relation to international bodies did not originate with Neville Lewis. It originated with Pratt and Morgan. So any response to time limits cannot be said that are directly related to Lewis.
Yes,
I concede it is related to both, but in terms of proportion, that is where there is some dispute.
At the time of Pratt and Morgan, there was no concern about the length of time which the Mercy Committee would have to wait, because the question of the Mercy Committee being required to consider the report of the international body under pain of having their recommendation or decision upset by a constitutional motion did not arise. At that time, it was still the law that the proceedings of the BPC were not justiciable. That was before the reversal of Reckley and De Freitas and Benny. But the amendment in the Constitution is specifically directed to the proceedings of the BPC.
I agree.
That only became the focus, only shifted to them when it was held that the proceedings of that committee were justiciable and subject to review, and that it was considered a breach of fairness, procedural fairness, for the Privy Council, that is the Barbados Privy Council, to perform its function without the benefit of this report from the international body.
I concede that, but I also say, prior to Lewis, there was Thomas and Baptiste, where the issue was as the time limits arose. And it could be a response to Thomas and Baptiste, as opposed to Neville Lewis. The issue, what I'm saying is that the issue of time limits and petitions to international bodies did not originate with Lewis. It originated, if you want to say, it was prior to Lewis. It arose in Thomas and Baptiste when they said 18 months was too short.
But even after Thomas and Baptiste, this amendment would have been not considered necessary, because Thomas and Baptiste said that it was fine for the Attorney General to impose time limits. But the time limits imposed in that case were disproportionate. But even after Thomas and Baptiste, there would hardly have been need for this constitutional amendment. Would there?
My submission still remains that the Section 6 does not authorize a petition to an international body. Section 6 was never designed to make such a fundamental change in the common law. It does not authorize it, it does not expressly say so. It is in terms of the international bodies, that section must be read in terms of subsection 3. We're looking at information. If the Governor General requires a particular set of information, he sets guidelines, he sets time limits in relation to a particular set of bodies. If he does not set it in relation to a particular set of bodies, he does not require to hear from you.
Yes. We had stopped you when you were going to your argument number 2, I think.
That's right. Yes, thank you.
Would you like to proceed?
That's right. My argument number 2 is simple. The argument number 2 is that the issue of the Constitution arose in relation to the exercise of the prerogative of mercy and the fairness thereof. It did not arise, the court never gave it as a reason for incorporating a treaty. And it must be seen in that context.
Yes.
And it was argued in that context. So those are the constitutional points. I'll move swiftly to the others, bearing in mind that my time is limited. Your Honors, I had already dealt with Section 12. I'm going to the last issue, so I'll move off that. That was the one. I had already dealt with Section 12, the breaches of the individual section. And my submission that there would have been no breach of Section 12 because it could not be seriously argued, paragraph 69 of my written submission, that the respondents were being executed pursuant to an order of the court. In relation to Section 15, our submission is that there was no breach of Section 15 in relation to the inhumane treatment. If you look at paragraph 76,
That's of your skeleton?
I'm sorry. Yeah.
No.
No, not the paragraph. Paragraph 80 of the judgment.
Okay.
Paragraph 80.
80.
Oh, 80.
Our submission has always is.
Just a second, just a second. Yes.
Our submission is that a delay, Pratt and Morgan never decided that a delay of 5 years equates to inhuman treatment. It never so decided. It appears from in this case, the 5-year norm. My understanding is that the Court of Appeal held the 5-year as a norm without doing further exploration as to whether there is inhumane treatment. What inhumane treatment is, you must show that it is not the delay itself that constitutes the inhuman treatment. It's the sentence after the delay.
Isn't the delay of 5 years what gives rise to a presumption, a prima facie case that there is inhumane treatment? And you would dislodge that by showing that that was not so.
That's right.
Yeah.
And in the instant case, our submission is that the threshold had not even yet been reached. You had not yet reached 5 years, so the presumption was not raised. That's our submission. If the case says that 5 years raises a presumption, 3.5 years, in my respectful submission, should not raise that presumption, and the court should have done an exploration, an examination to see if there was something that aggravated the death penalty. You are looking at aggravation. You are not only looking at delay.
Yeah, but when they're saying that in any event, looking at the past record of these human rights committees, that it is likely that 5 years will expire before a report is given to the BPC. And therefore, that would be cruel and inhumane treatment.
My respectful submission is wrong. If the cases suggest that 5 years raises this presumption, and you're less than 5 and you're speculating it is improbable but possible. We do not know what would happen. An event can be impossible and improbable. That is why men win lotto. Events can be impossible but improbable but possible. So it is impossible, it was improbable that the reports could come in, but it is also possible that they could come in. And once you reach the 5 year, once you reach that threshold, then there is the presumption. And even if the court was satisfied, look, the 5 years have not arisen, the court ought to have done some examination to say, look, the 5 years have not arisen, but there is sufficient evidence before me to show that there is an aggravation. It is not more than a straightforward death penalty.
But should the intermediate court not also take into account the likelihood of an appeal and the time which that would take?
In this particular case, all appeals, legal appeals, and I will come to the distinction between the analogy of a treaty application of an appeal. All appeals had been concluded. The board had dismissed the application.
No, I mean an appeal from its own decision. I mean, it's obvious that the Attorney General put considerable importance, and understandably so, on this case. And she herself appeared, the then Attorney General appeared herself on to argue the appeal. I would have thought that it was fairly predictable that there would be a further appeal to this court. Not so? I don't know. It seems so to me. And if so, is that not something that should realistically be taken into account?
Yes, it is, but I see no evidence in the record that the Court of Appeal took that into account. The Court of Appeal, in its reasoning, relied on the 5-year norm.
Yes.
That is what I'm saying. They did not weigh all the factors which ought to have been weighed in the scale in order to arrive at the conclusion.
Well, the appeal was, if filed, was likely to take it beyond 5 years, as indeed it has.
That is not a matter. I totally agree with the court, but that was not a consideration which the Court of Appeal this court has rightly taken into consideration. But what we are looking at is an appeal. We are looking at matters that occurred before. I do not think it is right for this court to correct the reasoning of the Court of Appeal.
But for the purposes of this case, is this not academic? Whether the Court of Appeal was right to conclude that at the time of their decision, the lapse of 5 years was sufficiently close to justify commutation of the sentence on the Pratt and Morgan ground. Is it not that we now have to consider the same issue on the basis of what is the present situation, which is that more than 5 years have now elapsed?
I would concede that. You have to.
Well,
it was not a consideration before the Court of Appeal at the time.
But since your time has already elapsed, should you not focus on points which are of practical importance to this case?
What is of practical importance to this case is in terms of the orders which could be made, and secondly, the effect of unincorporated treaties into the domestic law.
Yeah.
And in this regard, I would urge the court to adopt the reasoning of Lord Gough in Thomas and Baptiste. But before we get to that, Lord Gough had once advised that unless the courts move away from the commutation, it would be no incentive for the international bodies to respond. If the courts hold this, if there's this lax view that once you get 5 years and it is an automatic commutation of sentence, all the international bodies will do, unless there's a restriction, is to hold your application for 5 years. And the some courts should take a very strong hand in making that decision. In terms of the issue in relation to the due process, I urge the court to adopt the reasoning of Thomas and Baptiste, Lord Gough, page 434, Thomas and Baptiste,
Yes.
paragraph B. And the respectful submission is that an appeal to an international tribunal is not part of the normal appellate process, and that the analogy between the two falls down in that in relation to an appeal there is a right, whereas in the relation to the application to the body there is not. And it is set out at paragraph 434, the analogies, and where the analogies fall down. This passage beginning, the alternative argument is not assisted by the invocation of the analogy between rights of appeal granted by municipal law and the right under international treaty. There is an analogy, but as with all analogies, it is only valid and useful if points of similarity and differences are apt to the purposes. And he goes on, he makes the distinction between the right of appeal and a treaty, and a petition under a treaty. There's substantive differences. And what we are saying is an application to an international body is not a part of your appellate process, and as such is not covered by the due process. And then he goes on and he gives he advises of what due process is. Due process is law of the land, and is your domestic law. And due process is not really does not really capture your international law. And I would urge the court to follow in relation to the decision, the far-reaching decision, as to whether the executive can bind the state by ratifying a treaty. The arguments advance. This case is not only in relation to the death penalty, but if one takes the case of Lewis and you find any old treaty out there and you make an application under that treaty, the question is whether you acquire rights. And the law should not be extended to the extent where one can make an application under a treaty which is not incorporated and gain rights under that treaty. There must be limits placed on the process, since it would be inconsistent with the common law. And if that is what Lewis intends to set as a principle, I would ask that this court reject it and reject it out of hand. It is inconsistent with the common law. And unless there's any other thing I can assist you, those are the submissions.
Perhaps if I could just raise one final query on the most practical and least academic issue of all. Earlier, I gathered when you were dealing with the Court of Appeal's approach to Pratt and Morgan, you said that the presumption that 5 years suffices doesn't arise till 5 years are up, and in fact was only about 4 years, 5 months up at the Court of Appeal stage. So you accepted the presumption that once the 5 years is up, then there should be commutation unless there's some special circumstances.
I agree with that.
And then you further went on to say that, of course, now there's almost 5 years, 5 months expired. So it's well over the 5 year period. So the presumption of the application of the norm applies unless there are special circumstances. And you didn't go into those special circumstances. I think yesterday you suggested there ought to be. But as things stand at the moment, it seemed to me that it would follow that we should seriously consider whether to apply the Pratt and Morgan norm, so as to deal with the most practical issue facing us.
Yeah. That is on the assumption that the court is satisfied that there was a breach under Section 15 the inhumane treatment, that is an option open to the court. If the court is of the view of the Court of Appeal that there was simply a breach of the BPC's Section 78, then that is not an option open to the court.
But is it not?
The delay itself.
That's right. So you have to find that there was a breach of Section 15. In order to get a 24 remedy, the court must be satisfied that there was a breach of 15 or one of the other sections.
Not that there was, but that there would be.
Or there will be. Or there will be. Yes, there will be.
And is that not satisfied by the mere lapse of 5 years and 5 months?
It is not. Let's put it this way. In the peculiar facts of this case, no evidence has been laid in the court below so as to rebut that presumption which may arise. So I am bound by the evidence which is before you.
But
it is a presumption, and no evidence was led by the Crown in order to rebut it. So I am bound by the presumption is not the delay itself.
Why not?
It is.
That's what Bradford Morgan is all about. Delay.
But what they say, it is not the delay itself.
No.
It's the aggravation. It is not the delay. The detention of a man for
hanging him after 5 years is prima facie cruel and inhuman. Is that not Bradford Morgan?
Yes.
In a nutshell.
Yeah. My Lord, this is what is said. Your Honor, this is what is said in Thomas and Baptiste. Pratt did not establish the principle that prolonged detention prior to the execution constitutes cruel and unusual punishment. That's what the Privy Council said. Pratt did not establish the principle that prolonged detention.
Read on.
It goes on. It is the carrying out of the death sentence after such detention that constitutes it.
Yeah.
So the distinction between the distinction is being made between the delay and the effect of the delay. This is because additional cruelty over and above, and that is the point that is being made. Pratt does not establish 5 years equals inhumane treatment.
Not unless you hang him.
No, it doesn't. What it's saying, it is because of the additional cruelty over and above that inherent in the death penalty itself is involved in carrying it out. So I find that paragraph is quite instructive, and it makes a fine distinction between the delay and the additional to the penalty. And those are my...
Let us just get down to basics. Is there in your suspicion any ground for not commuting in this case, given the lapse of 5 years and 5 months?
On the facts, I see none.
Thank you. Okay, thank you, Mr. Ford. Thank you very much. Mr. Shepherd.
Your Honours.
Before you begin, may I just remind you that we will take a short break at 11 o'clock.
Thank you,
Yes.
Your Honour. Your Honours, the respondents will argue that Lewis was rightly decided and that Lewis ought to be followed because not only was it rightly decided, but also on the principle that even though this court is not bound by previous decisions, it ought to follow Lewis. Those are the two limbs under Lewis. And then, of course, Your Honours, the other arguments relate to the question of the interpretation or the force of Section 11, and the justiciability of the power of mercy in the Barbados Privy Council. I'm hoping, Your Honours, that in relation to the argument that Lewis ought to be followed on stare decisis principles, you will allow Mr. Mendez to take that point. And then the remaining points I will take. And I was hoping that in those circumstances you would allow Mr. Mendez to start for and on behalf of the respondents.
Yes, very well, Mr. Chairman.
Thank you. Thank you, Your Honour.
Thank you very much, Your Honours. We accept that this court, as the final court of appeal of Barbados, is empowered, as a matter of its inherent jurisdiction, to not follow any decision of any court on the issues that are relevant to the disposition of this appeal. We accept.
So, are you saying there's no stare decisis as regards this particular case?
I'm saying that you are not bound, no, but that there are good reasons, even if you think that Lewis is wrong, to follow it nevertheless. That, at the end of the day, is what I'm coming to. I'm saying, in other words, that even though you have the power to depart from Lewis if you think that it is wrong,
Well,
you do not necessarily have to exercise the power.
Not a question from departing from it.
Well, Your Honor, I'm
Not, but we are the highest court. There is no court higher than this court. So it's not a question of stare decisis, is it?
It's a question of not following it.
Yeah.
Yes, because if you're not bound by it, there's no question arising of following it. But maybe my choice of words is not apt. It's not a question of departing from it. It's a question of whether you will follow it or not. And what we are saying is that even though you might have the power to not follow Lewis, if you think it is wrongly decided, we say that in this case, you ought nevertheless to follow it. The point is, Your Honours, you are empowered clearly to decide not to follow your own decisions at some point in time in the future, if you think on reflection that the decision is wrong. But again, because you have the power doesn't mean that you have to exercise it in every case. It would depend upon the circumstances. The fact is that you have been empowered as the final court of Barbados to declare the law at a point in time when Barbados has already developed a mature legal system. There has now been over 40 years of independence, during the course of which a number of principles have been examined, a number of issues at common law and as a matter of interpretation of the Constitution have all been established. In other words, you don't come to be the final court of appeal of Barbados with a clean slate. You are meeting the legal system of Barbados with already developed principles. And therefore, the question which would arise in any case that comes before you is whether you will take a different course that has already been taken in relation to Barbados or not, irrespective of whether you think that the course that had been taken so far is wrong or not. Now, my learned friend on the other side had submitted that the courts of Barbados are not bound by decisions of the Privy Council on appeal from other jurisdictions. And I would first like to address that principle. We respectfully submit that he is wrong. And in that regard, unfortunately, Your Honours, I have to add to your burdens by asking you to look at a bundle of cases, 9 in all, that address this particular point. And you will see from the list, Your Honours, that I will be referring to decisions of the Privy Council itself on this question, as well as decisions of the Court of Appeal of Jamaica, the Court of Appeal of Trinidad and Tobago, the Eastern Caribbean Court of Appeal and the Barbados Court of Appeal. And you will see that in each case, there's unanimity in the view that the local courts, that is at the level of the Court of Appeal, all consider themselves bound by decisions of the Privy Council, even those emanating from other jurisdictions. If I may start with the Privy Council case that is first on the list of Bakshuddin and Bakshuddin, there's a decision of the Privy Council from appeal from the Court of Appeal of Eastern Africa. And I will refer you to the head note, which should be sufficient. Sorry, just getting accustomed to this technology. And you will see the part that is highlighted says that on the assumption that the rights of the parties were to be determined without reference to any ordinance dealing specifically with wax, that the interpretation of the Mohammedan law given by the Judicial Committee of the Privy Council in a series of cases was not confined to that law as applied or administered in India, that on a question of Mohammedan law, decisions of the board given in appeals which came from India are binding on the Court of Appeal of East Africa in appeals to that court from the Supreme Court of Kenya, and that accordingly the Court of Appeal of East Africa will write in following the decision of the Privy Council in Abdul Fattah Mohammed Ishaq and so on, and holding that the WAC was invalid. So in 1952, the Privy Council was taking the position that the local courts were bound by decisions of the Privy Council from other jurisdictions. Your Honors, the next four cases on your list are all...
Isn't that in relation to a particular system of law, like the Roman Dutch, like in this case, Mohammedan law?
Of course, it would be, as long as the circumstances are the same. You can well imagine that there would be legal systems in which the circumstances are so different that there may be justification for departing from a Privy Council decision.
No, but what I'm saying is that the system of law there is like, it's different from the common law. It's the Mohammedan law, the Islamic law that was being applied here. So the Islamic law declared in one jurisdiction is not likely, if Islamic law is universal, it's not likely to be very different whether it's in Port of Spain or in Nairobi.
Yes, I'm accepting that, and I'm saying that it is accepted that a country may nevertheless, a court may nevertheless decide to depart from a decision of the Privy Council on appeal from another jurisdiction on the basis that local circumstances demand a different rule. In other words, the local circumstances rule has always been applied in departing from decisions of English courts, even before independence, at a point in time when we may have thought ourselves to be bound by decisions of the House of Lords, for example. Local circumstances rule always justified a departure from any English decision. But the point that I'm making is that the Privy Council is accepting, certainly in circumstances where there is no difference between the legal systems, that one court in one country should consider itself bound by decisions of the Privy Council on appeal from another court. Now, that is in direct answer to my learned friend's submission, that simply because the Privy Council is hearing an appeal from the courts in one jurisdiction means that it cannot bind the courts of another jurisdiction. And I'm saying that that on the authorities is not so. And as you will see from the decisions of our local Court of Appeals right through the Caribbean, we have accepted that position.
Yes, go ahead.
Much obliged, Your Honor. As I said, the next four cases, 2 to 5, are all decisions from the Jamaican jurisdiction. I'll ask you to look only at number 4 for the time being, and that is the decision of the full court of the Supreme Court in Ex parte Grange, and the relevant page is at page 530, which I will try to bring up on your monitors.
What page?
It's at page 530 at letter G, and it's up there on your monitors. I'll try to put it. There it is. It says, of course, the judgments of the Privy Council are binding on us, although in some cases they were given in cases coming from another jurisdiction, as the issues of law in these cases are the same, and the Shuen case is cited as the for that. The next case that is of relevance, Your Honors, is the case of Williams and the Queen, which is a case from the Trinidad and Tobago jurisdiction. Once again, I'll try to bring up the relevant passage on your monitors. At page 548, letters B to E. This case is particularly interesting because what was being accepted by the Trinidad and Tobago Court of Appeal is that decisions of the Privy Council on an appeal from Jamaica actually resulted in the overruling of a decision of the Court of Appeal of Trinidad and Tobago. You will see in that passage that is highlighted there on the monitor, it says, in the instant case, however, it is not necessary to call in aid the principle enunciated in Taylor's case, since it is clear that the decision in Johnson's case, which is a decision from the Court of Appeal of Trinidad and Tobago, is inconsistent with the decision of the Privy Council in Palmer's case, which was on appeal from Jamaica. Johnson's case, therefore, must now be considered as having enunciated an incorrect principle of the common law in relation to the offenses of murder and manslaughter, where the issue of self-defense is raised and left to the jury for their consideration. To the extent of this inconsistency, therefore, Johnson's case must be regarded as having been overruled or as one which should no longer be followed. Then there is the Court of Appeal of the Eastern Caribbean States in Richards and the Attorney General. The relevant page is at page 147. And this was a case dealing with delay in carrying out the death sentence at a point in time when Pratt and Morgan had not been decided. And let us see the Eastern Caribbean Court of Appeal says, counsel for the appellants invited this court to depart from the opinion of the majority and to follow the opinion expressed by the minority in Riley's case. This we should not do. Appeals lie from this court to the Privy Council, unless and until the Privy Council decides to endorse the opinion of the minority in Riley's case, we should consider ourselves bound by the opinion of the majority. And then finally, to complete the review of the region, is the decision of the Court of Appeal of Barbados in the case of Bradshaw and the Attorney General. This is at the Court of Appeal level, and you will find that at the Respondents Bundle, Volume 1, tab 11 at page 104, dealing with the Riley case as well. The court says there, in these circumstances, this court is, in my opinion,
Just a minute.
At page 104 of the judgment. Yes, it's in these circumstances, this court is, in my opinion, bound by the decision of the majority in the Riley case, and applying this reasoning on which that opinion is based, the question is whether the delayed execution of a sentence of death by hanging can escape the unambiguous prohibition imposed by the words in Section 15(2). The court said this after it compared the relevant provisions of the Jamaican Constitution with the provisions in the Barbadian Constitution and found no difference, and therefore expressed that view that they were bound by the decision in Riley. On the last case that I would ask you to look at is another decision of the Privy Council in De La Sala and De La Sala. And that case considered the question whether the Hong Kong courts were bound by decisions of the House of Lords as opposed to the Privy Council. And you will see that in saying at the end of the day that the courts, Hong Kong courts, should consider themselves to be so bound, the Privy Council referred to the fact that the Privy Council and the House of Lords shared membership, so that unless we expect the members of the board to be schizophrenic, you would expect that once they make one decision sitting as the House of Lords, then they would follow that decision when they sit in the Privy Council. Ordinarily speaking, of course, there are many examples where that has not in fact happened. And you will see that the question, again, I've highlighted it.
It's on what page?
Sorry, I'm looking at page 398. And then that portion is highlighted on your monitor. It says, so too in Hong Kong, where the reception of common law and the rules of equity is expressed to be so far as they are applicable to the circumstances of Hong Kong or its inhabitants, and subject to such modifications as such circumstances may require. A decision of the House of Lords on a matter which in Hong Kong is governed by the common law by virtue of the application of English law ordinance is not ipso facto binding upon a Hong Kong court, although its persuasive authority must be very great, since the Judicial Committee of the Privy Council, whose decisions on appeal from Hong Kong are binding on all Hong Kong courts, shares with the Appellate Committee of the House of Lords a common membership. This board is unlikely to diverge from a decision which its members have reached in their alternative capacity, unless the decision is in a field of law in which the circumstances of the colony or its inhabitants make it inappropriate that the common law in that field should have developed on the same lines in Hong Kong as in England. Different considerations in their lordships' view apply to decisions of the House of Lords on the interpretation of recent legislation that is common to Hong Kong and England. Here there is no question of divergent development of the law. The legislature in Hong Kong has chosen to develop that branch of the law on the same lines as it has been developed in England, and for that purpose to adopt the same legislation as is in force in England and falls to be interpreted according to the English canons of construction. What their lordships have already said about the common membership of the Judicial Committee of the Privy Council and the Appellate Committee of the House of Lords applies a fortiori to decisions of the House of Lords on interpretation of recent English statutes that have been adopted as the law of Hong Kong. Since the House of Lords as such is not a constituent part of the judicial system of Hong Kong, it may be that in juristic theory, it would be more correct to say that the authority of its decision on any question of law, even the interpretation of recent common legislation, can be persuasive only, but looked at realistically, its decisions on such a question will have the same practical effect as if they were strictly binding, and courts in Hong Kong would be well advised to treat them as being so. So that the position is that even in relation to decisions of House of Lords, where they are interpreting legislation that is essentially copied in the local jurisdiction, that the local courts ought to treat those decisions as binding. Now, of course, this is pertinent to this case because the relevant provisions that we are concerned with of the Jamaican Constitution are practically identical to the decisions of the Barbadian Constitution.
Don't you think in this Hong Kong case that it's a quantum leap? Because here's the House of Lords obviously was not the court of Hong Kong, final court the Privy Council was. So to say because of the fact that they compose of the same person, that they should now follow that, I think it's stretching it a bit too far. In relation to the Jamaica and Barbados, it's different because the Privy Council is the final court for both jurisdictions. I can understand that. But in this Hong Kong case, it seems a bit strange.
I'm using it just by way of, I'm using it just by way of the illustration of the extent to which the point has been taken. Of course, in a case where you share the same court as your final court, then the point is even stronger. And I believe this is why the local courts have, over time, considered themselves to be bound by decisions of the Privy Council from other jurisdictions. Of course, as long as the issue is the same.
The point would be even stronger if the judicial committees sat in bank.
Absolutely.
Or in bar.
Bar. As Lord Hoffman suggested in his dissent in Lewis itself, that would have certainly made the area of law a bit more stable than it has been.
Yes.
But the point that I'm coming to ultimately, Your Honors, is that at the point after Lewis was decided, and having regard to the practice of the courts in the region, the Barbadian courts were well advised to consider Lewis as binding upon them. And therefore, when your honors assumed jurisdiction as the final court of appeal of Barbados, the state of the law at that point in time was that Lewis bound the local courts. Of course, the Privy Council as the highest court was still free to depart from Lewis if it chose to do so in relation to Barbados. But if you ask the question, what was the law of Barbados on this particular point at the point in time that you assumed jurisdiction, the answer, I respectfully submit, would have to be the law as stated in Lewis. Now, that again does not mean that your honors must follow Lewis. What we are submitting is that you have to consider the question of following Lewis in the context that Lewis, on previous principles, is considered law because at that point in time, the Privy Council was the highest court of appeal in Barbados.
A point which is probably only of academic interest is whether the Court of Appeal was bound by Lewis.
Yes.
Sitting at a time, or giving their judgment at a time when the Privy Council was no longer the final Court of Appeal.
Yeah, yes, Your Honor. But I'm taking it a step back. I'm not.
What is the answer to that?
At that point in time, well, it's a gray area, I think,
Right.
because they certainly would not know what the views of this court would be at that point in time. I'm turning the clock back slightly to the point in time when Lewis was decided. I'm saying as of that date,
Yeah.
the practice was that that would be considered to be the law of Barbados. I imagine that at that stage, the Court of Appeal would have been in a difficult position, trying to decide what it should do when it does not know the views of this court. Again, I think it would have been and this is what they did, it would be a wise course in those circumstances for the local court to follow what was a decision of its highest court at that point in time.
But up to the time that the matter was heard in the Court of Appeal, that is to say the 11th of March, that would have been the law. Lewis would have been the law in Barbados.
That is correct.
So unless they
gave a decision.
They gave a decision on the 31st of May. Unless they hold back the parties and ask for new submissions, I don't see that they could simply have barked on a frolic of their own.
I think so, but I say in any event, it would have been the wisest course to follow what was considered to be the law in Barbados at that point in time. The submission that we are making essentially, Your Honors, is that the question that you ought to ask yourself, therefore, is whether, even if you think that Lewis is wrong, you ought to not follow it in relation to Barbados. And we are respectfully submitting that in that regard, you ought to apply the same principles that you would apply in deciding whether you should follow one of your own decisions. And in that regard, you are assisted by the way in which courts have dealt with similar problems before, that similar problem before the Privy Council, as well as the House of Lords. And we have set out those principles in our written submissions, in supplemental submissions. We have referred to a text on precedent in English law by Cross and Harris, and we ask you to consider those principles in deciding the basis upon which you will depart from decisions, generally speaking, in the future. Now, in that regard, we submit the following as being relevant factors to be taken into account in deciding whether you should not follow Lewis in the event that you consider that it was wrongly decided. The first point that we ask you to consider is that Parliament amended the Constitution on the basis that Lewis was the law in Barbados. Now, Your Honors, you have the Hansard reports before you, and I think the relevant page is page 7 that His Honor Justice Nelson was referring to earlier. And on that page, you'll see this clearly indicated by the Honorable Attorney General piloting the bill that was to deal with Lewis, that the Governor General is being empowered to set guidelines. So essentially the Constitution has been amended, the law in Barbados has been developed in that regard on the basis that the Lewis principle is the law in Barbados. And therefore, to not follow Lewis at this stage would undermine that understanding, would disrupt the harmony that Sections 78, 5, and 6 attempted to create as in the aftermath of Lewis. So that is the first reason why we say that you ought not to not follow it. The second point is that if you were to decide that Lewis is wrong and that it is not the law anymore in Barbados, then that would put the law in the entire region into a state of flux, because you would have a situation where, in relation to Barbados, and presumably the same may apply to Guyana, if that issue does arise, assuming that the Constitution is similar, you would have one position applying to Barbados and Guyana, and another position applying to the rest of the Caribbean.
You mean in respect of the death penalty?
In respect of this particular point, that is to say, the right to be heard before the Mercy Committee.
But
and
is there capital punishment in Guyana?
Yes, yes.
I'm advised that it's still there.
Hasn't been carried out in a long time, but nevertheless, it is
mandatory.
It is dead.
Variable quantity in the region, is it not?
Doesn't the Constitution of Guyana require you to pay respect to international human rights norms?
I don't know. I don't know the answer to that.
I think that is
Yes, there is an amendment.
a clear provision of the Constitution.
Well, as I say, it may be different for Guyana because of their peculiar provisions.
Very different from this.
So you will have a situation where the highest court in Barbados, and one which may become the highest court of other courts in the region, is adopting one position, and the highest courts of the courts in the other member states in the region having to follow another decision, a decision of the Privy Council. So it will create that state of flux, as I call it, in the region. And
but is not a case for the other people accelerating their accession to the CCJ?
Well, I don't know if that would be a case for that. Yeah.
Presumably, it would also lead to a 7 or 9 member committee of the Judicial Committee of the Privy Council sitting to review the position as a whole, because what does strike me as rather remarkable was that in the Neville Lewis case, 5 of them, or at least 4 out of the 5, took it upon themselves to take a very different approach to the standard approach as to international treaties not conferring substantive rights on nationals under domestic law. And it would appear that Thomas and Baptiste was a rather anomalous exception, and they chose to extend the anomalous exception rather than review the whole position. So perhaps it is about time the Privy Council, consisting of 7 or 9 members, did review the position, which of course they would do if we took a different approach from Lewis and wouldn't quite go as far as Lewis went.
I would think that they should, if you were to take a different position. And but even on the question of whether there was a right to be heard before the Mercy Committee, the court was departing from De Freitas and Benny and Reckley, which was a recent decision. So far be it from me to suggest what was the Privy Council ought to have done, but probably they ought to have done what they did in Pratt and Morgan, which is to convene a larger number of members than normal. But the point that I'm making here, I'm saying that in Lewis, it may have been appropriate to empanel a larger number of judges in the same way that they empaneled a larger number in Pratt and Morgan.
Or in Matthew.
Or in Matthew, as the case may be. Now, but the point is that a decision of this court that differs from Lewis will cause a re-examination of the law in the entire region as a consequence. And therefore that is a factor that should be taken into account. I just point out that in Boyce and Joseph itself, that one of the reasons that the court gave for departing from Rudal, even though Rudal had been cited such a short period of time before, was the impact that the decision in Rudal would have upon other countries in the region, including Barbados. And so that we are saying the reverse ought to be, that is clearly a factor. The impact of the law in the region would be a factor that the Honour should take into account.
I think, this may be a matter which Mr. Shepherd will address. But I think one of the unsatisfactory ways in which the law was changed by the Privy Council was that the two stages in which they did it, with that is between Thomas and Baptiste and Lewis, with Higgs coming in between, and they did it originally on the basis of the due process clause, and then you had Higgs, which said, well, that is, they couldn't have meant to overrule the other two earlier cases, Reckley and what was it?
Fisher.
Fisher number two. Fisher number two. So that must be explainable on the difference in the constitutions. And then they come in Lewis and they say, no, nonsense. There is no difference really in the two constitutions. Well, in fact, it was set first by President Ford, or Justice of Appeal Ford in the Court of Appeal. So that you are kind of finessed, Lord Hoffman and those who had decided the earlier cases in that way. And I think that's something that Lord Hoffman complained about, that they had not confronted him, his decision head on.
Well, I think that, again, you're right, Mr. Shepherd will probably deal with this in more detail, but from my knowledge of it, the way it developed, there were the earlier Fisher decisions. Then there was the Trinidad and Tobago decision, Thomas and Baptiste, in which it was said, well, there's a due process clause which you don't find in the Bahamas, and therefore we should take a different look at it. And then after Thomas and Baptiste, the Jamaican case arose, and it was said, well, now that you have decided that due process includes it, is there any difference between due process and protection of the law? And that is a point that was not raised in Fisher. And any of the cases coming from the Bahamas, lawyers never prayed in aid the protection of the law. That was done for the first time in Lewis. So I think that is maybe that explains the progression in the law in this particular area.
Well, I mean, it doesn't, however, answer the point that I thought Lord Hoffman was making, that, or arises out of his judgment in Higgs and his puzzlement, really, as to what is going on, and his reluctance to say that Thomas and Baptiste was wrong. And I think the only reason that Lord Hoffman did not say that Thomas and Baptiste was wrong was because he thought, well, it could be reconciled on the basis of the difference in wording. Not so?
Well, again, I don't recall him giving any consideration to the protection of the law. He did. I think you can read what he is saying as expressing concern about the decision in Thomas and Baptiste. He never, as you rightly say, actually questions it. But the point is that the argument that the due process of law is to be equated with the protection of the law was not before him in Higgs. He didn't have to consider it.
I think he made his views on it very clear.
Yeah, well, you could read between the lines. It's it.
Beg your pardon?
I said one could read between the lines.
Yes, yes. They were sort of double space lines. But, you go ahead.
Much obliged.
You go ahead.
The third factor that Your Honors ought to take into account in deciding whether to not follow Lewis, if you think it wrong, is that there are no changed circumstances since Lewis, at least none have been referred to, which would justify a change in the law. Related to that is the point that the questions or the issues that my learned friend for the appellant has raised were all raised in Lewis. They were all fully argued, and there is no new factor since then. There's no new argument which has been put before Your Honors, not put before the Privy Council at that point in time, which would require a reconsideration.
Mr. Mendez, to what extent, if at all, is it a relevant factor that this is a new court composed of judges who reside in the Caribbean and who are familiar with local conditions and whose membership will not fluctuate as wildly as is the case with some other courts? Is that a new factor?
It doesn't occur to me right off the bat, Your Honor, in what way that would affect your approach to previous decisions. I would think that if, to the extent that your membership may be stable, it would mean that you would be even slower to depart from your own decisions. I think that would occur to one immediately. How that would affect your approach to decisions which were considered to be the law of a territory prior to your assuming jurisdiction, I'm not entirely sure how it would impact upon it.
But it really is a question of how a final appellate court will treat previous Privy Council decisions. And I don't know if you remember the case of Persad and Plantations Versailles, where Mr. Justice Crane said it is my considered opinion that the doctrine of stare decisis, insofar as that court, the Privy Council, was concerned, is a dead letter with us. And he went on to say that the ipso jure, those pronouncements have ceased, that's the pronouncements of the Privy Council, have ceased to be authoritative. And one could be as extreme as that.
Well, no, we accept that position. We
Yes,
accept that you are in the same position as the Guyanese Court of Appeal was once appeals to the Privy Council had been abolished. We accept that you can depart from any decision of the Privy Council. All we are suggesting is that
Mr. Mendez, my problem with that statement is saying that statements of the Privy Council or decisions and propositions of the Privy Council cease ipso jure to be authoritative. Now, I don't necessarily share that view, but
well,
I'm saying that is one extreme.
Well, I have always interpreted that decision to mean not that we will not take account of it at all, not that we will not give it due weight and due regard as being part of the law of Guyana. Certainly, I understand this statement in relation to current Privy Council decisions, that is, decisions of the Privy Council rendered after the Guyanese Court of Appeal assumed jurisdiction as a final
But in Australia,
appellate court.
the High Court of Australia said it's not bound by any previous Privy Council decision, whether given before or after the 1986
And we
Act.
accept that position, Your Honor.
So that it's not a question of whether it was before or after.
No, but the distinction that I'm making is that the position before has to be considered differently to the position afterwards. Because before you assume jurisdiction, the Privy Council was the highest court and therefore was declaring the law for Barbados. And therefore, when you are considering a decision of the Privy Council prior to your assumption of jurisdiction, you will be considering a decision that is the law of Barbados in accordance with the rule at that point in time. It doesn't mean that you can't depart from it, but it means that you will be departing from the decision of a body that is at the same level as you are. I'm submitting that you should treat such a decision in the same way as you would treat your own decision. And the rules that you would develop for departing from decisions ought to be the same for a situation where you are departing from your decision as when you are departing from a decision of a Privy Council that is considered to be the law in Barbados prior to your assumption of jurisdiction.
But this court is ordinary jurisdiction. And I think that I agree with what you've said. And perhaps the decision should be taken as being highly persuasive, not necessarily to be bound. Because
I think I'm going to have to ask, we interrupt at this stage because we have to take a break at 11, and it's nearly 10 past. Before we do, if I may just ask you to, perhaps you can respond after the break. But as we are discussing relevant factors as to whether it would be appropriate to not to follow Lewis or not, I wonder whether it is also a relevant factor that Lewis and Baptiste both decisions that reverse fairly recent decisions, as you acknowledged, of the Privy Council itself, and also that they are not, neither of them were unanimous. In one case, there were two dissenters in the other one. And if one reads the decisions, as we all have in the death penalty cases in the Judicial Committee, it is quite obvious that there is a division in the Judicial Committee and among the Lords of Appeal in ordinary with regard to their approach to the issues arising in these cases. And that they consistently come down on different sides of the line. And there have been suggestions that coming from among their number, that the thinking of some is influenced by their doctrinal disposition. I'm not intending in any way to say anything negative about those who have participated in these decisions, because I want to stress that my admiration for that particular court is totally unchanged as a result of them. But these are realities, I suggest, which may have some relevance to the question of whether we are going to not to follow Lewis, if, of course, we are persuaded that it is wrong. But it is now little after 10 past 11, so we'll take a 15-minute break, and well, we'll make it a little longer, and we will resume at 11:30.
Much obliged.
All rise. For the President and judges of the Caribbean Court of Justice.
Mr. Mendez.
Your Honors, I'm giving consideration to the question which you asked as to whether it would be a relevant circumstance to take into account the fact that there were dissenting judgments in the major decisions that we have that you have under consideration. I imagine that it would be relevant because certainly in the past, dissenting judgments have turned into majority judgments at later dates. And in this area, that has happened. The dissenting judgment in Riley turned into a majority in Pratt and Morgan, for example. So certainly it is of relevance that there was a difference of opinion among the judges of the highest court before. That would be a factor to take into account, no doubt. As far as the doctrinal differences are concerned, I'm not too sure exactly how Your Honors would take that into account without some sort of declaration from the judges themselves as to their doctrinal position.
But which judges? Privy Council.
Sorry?
Privy Council judges?
The Privy Council judges, yes.
Yeah.
I did make a quick check of the composition of the boards in the relevant decisions, Thomas and Batiste, Higgs and Lewis, for what it is worth, and noted that the majority in Thomas and Batiste was Lords Millett, Stain, and Brown Wilkinson. The minority were Lords Gough and Hobhouse. Then in Higgs, Lord Hobhouse was in the majority with Lord Hoffman and Justice Henry from the New Zealand Court of Appeal. In the minority were Lords Stain and Cook. And then in Lewis, Lord Hoffman was in the minority with the majority comprising Lords Slynn, Nichols, Stain, and Hutton. I'm not too sure exactly what one would make of that if, for example, because the composition is changing. Lord Stain certainly is featured in all of the cases. Lord Hoffman featured in 2, and he was on the other side of Lord Stain. So I imagine that Your Honors is inescapable in death penalty cases, not to attribute to judges some doctrinal position, but to the extent to which Your Honors can take that into account in deciding whether, or as a relevant factor in deciding whether to depart from a previous decision. I would think that I can't see that it is something that is relevant, that ought to influence you one way or the other.
Yeah, see that I mentioned that in passing simply as perhaps a footnote to the fact that there was this split,
yes,
and the split appears to have divided the Judicial Committee or the Lords of Appeal in ordinary into loosely into 2 groups, if you like, who are consistently on opposite sides of the fence. And I think if you look at Rudall and then Boyce and Joseph and Matthew, you will see a continuation of that trend. But the other more important point, which you haven't referred to, was the fact that, which is, I think, the first one I mentioned, that these decisions are reversals,
yes,
of earlier decisions of the board itself.
In the case of, certainly in the case of the question whether there's a right to be heard, Lewis does constitute a reversal of very recent decision.
Yes.
I should point out that we will have to take into consideration the fact that outside of the death penalty itself and the prerogative of mercy, there were also taking place developments in the laws in relation to the right to be heard, in relation to prisoners who had been convicted of murder and had been sentenced to life imprisonment, for example. I'm referring to that line of cases beginning with the House of Lords decision in Doody, where there was definitely a trend in the direction of allowing more opportunities to be heard by prisoners in respect of whom very important decisions were being made about their lives. So there was a trend in the direction of allowing persons in those circumstances to be heard. So that to a great extent, Lewis may not have been a surprise development. In addition, after Reckley, or the decision in Reckley was severely criticized academically. There are a number of articles that have been produced criticizing that development, criticizing the failure of the House of Lords, the Privy Council, not to depart from the Freitas and Benny. So that Lewis, on that aspect of it in any event, was not a surprising development,
No.
I would respectfully submit. On the other point, of course, you had Thomas and Batiste deciding the issue in one way, but on the basis that the due process clause incorporated a common law principle, which I don't believe...
I must admit, Thomas and Batiste was a surprise to me, but... but I got over my surprise.
So that, and I don't understand any of the members of the board on either side of the fence, as it were, to be questioning the common law principle that you ought not to be deprived of the opportunity to pursue some appellate process. I don't remember anyone dissenting from that principle. The question is whether that principle is now incorporated into the due process clause. This is what Thomas and Batiste decides. Lewis is an extension to the extent that they say that due process is the same as protection of the law. So therefore, that the common law principle is incorporated in that as well. But the point that I'm making in this aspect of the submissions that we're putting to you is that a decision on your part not to follow Lewis will involve, first of all, or may involve a decision that the due process clause is not to be equated with the protection of the law clause. And in addition to that, it would have to be that you have decided not to follow Thomas and Batiste either, or a combination of those. So that the disruption, as I have referred to it previously, in the state of the law in the region would extend even further to those territories that, well, including Trinidad and Tobago, which have followed Thomas and Batiste and also have followed Lewis. Saying these are all factors that your honors ought to take into account. The other factor is that as a consequence of Lewis, persons on death row, including the applicants, of course, would have acquired a legitimate expectation of being allowed to approach international human rights bodies for opinions, which they could then use to persuade the Mercy Committee to not allow the death penalty to be implemented in relation to them. I don't know exactly how many people that would affect at this stage. To a large extent, I suppose it would depend upon the way in which your honors ultimately interpret the amendment to the Constitution. If the right is in there quite apart from Lewis, then everyone would be able to lay claim to the right to go to these international bodies. The other factor that you ought to take into account is that this case concerns the imposition of the death penalty, and the rules that you are being asked to not follow, that is, the right to be heard before the Mercy Committee and the right to get an opinion of an international body, are rights which may, once exercised, may result in the death penalty not being implemented in a particular case. In other words, these are rules which give persons on death row more opportunities to persuade the Mercy Committee, the Barbados Privy Council, to make a decision in their favor. In Lewis itself, the reason why the court felt able to depart from Reckley and De Freitas and Benny was precisely because that it involved life and death, and it was giving persons on death row the opportunity to persuade the Jamaican Privy Council in that case to make a decision in their favor. Another relevant consideration would be whether Your Honors consider that not following Lewis would result in an improvement in the state of the law in Barbados. We respectfully submit that, on the contrary, the legal system, insofar as the administration of the death penalty is concerned, would not be improved. As a matter of fact, it would be worsened in this sense. The Barbados Privy Council has to make a decision constitutionally as to whether the death penalty should be implemented in any particular case. We respectfully submit that they would be in a position to make a better decision after having heard the person most affected by their decision. They would also be able to make a more informed decision, having had the opinion of an international body on the question whether any of the rights of the condemned man under the treaties have been violated.
You know, I don't know, I mean, but I've been wondering about, in practical terms, what how much assistance the report of the Commission would provide. And in that regard, I would have wished to have had the opportunity of seeing one of these reports, which I haven't had. But you know, I'm just wondering what additional fact or insight would such a report provide to the Barbados Privy Council? One knows that the stand of the Commission with regard to the death penalty, and that does not vary from one case to the other. I mean, it is, as I understand it, it's interprets the convention as really outlawing the death penalty, and therefore I would imagine that it would in every case recommend against the execution of the convicted person. But that is a position which is predictable, which is known. But with regard to the facts of the particular case, the individualizing of that case, that surely would one would expect would have been adequately done by material within the jurisdiction obtained by the BPC. So in practical terms, really, how much assistance would the report of the Commission be expected to provide?
Your Honor, in my experience, the complaints that are made to these international bodies usually involve allegations of violations of rights during the course of the trial. It may be incompetent counsel, it may be a direction by the judge, it may be delay in bringing the person to trial, it may be prison conditions. A number of different complaints may be made that during the course of the trial or during incarceration, a right under the treaty has been violated. and the commission would then make a recommendation as to what ought to be done on the basis of the particular violation. They don't always recommend that there be a commutation of the death sentence. Sometimes they recommend compensation. But if they do find a violation that is serious enough and they do recommend a commutation, then certainly that would be information that would be relevant to the
But all these matters that you have mentioned, both with regard to the alleged improprieties in the trial, irregularities in the trial, and also the complaints about prison conditions, are matters which would and should have been raised in the internal processes.
And sometimes they are. And
well, why should really, if they haven't been, why should there be a further opportunity given to bring forward the same points again?
Because it would be of interest for the Barbados Privy Council to know that that in international law, as opposed to domestic law, it is considered that a right has been violated. There have been occasions in my experience where the local courts, including the Privy Council, is of the view that no right has been violated, at least none justifying the quashing of the conviction. And yet still the Inter-American Commission, or sometimes the court, is of the view that a violation of the treaty has occurred. So it would be of relevance for the committee to know, the Privy Council to know, that in relation to a particular applicant, it is considered that the execution is in violation of international law as opposed to domestic law.
Yeah,
that
but counsel, with respect, I think that the gravamen of this issue goes way beyond the administration of criminal justice. You are here concerned with a juridical postulate which claims that by ratifying a treaty, a human rights treaty in this context, the executive can in effect change the municipal law, including the supreme law of the state. That has extremely serious implications way beyond the administration of criminal justice. That is the issue. And I will explain why. For small countries as we are here, states are induced more often than not to sign and ratify a host of instruments, the implications of which you don't even understand. Are you suggesting that in such a situation, the executive in so doing can change the law of the land, including the supreme law? That is a question I think you should consider, Counsel.
Your Honor, whether a state has acceded to an international treaty kicking and screaming along the way, whether they have done so voluntarily because they agree with the principles under the treaty, with respect, don't think that it makes much of a difference. Certainly, I don't know if that can be said of Barbados, for example. In my experience, Barbados is certainly one of the countries in the Caribbean, I may be wrong, that has voluntarily acceded to a number of treaties. I may be wrong, but in any event, I don't think that it's a relevant consideration how you came to the treaty. Further, we don't say that simply because the executive has ratified a treaty that ipso facto it becomes a law. And I think that the Privy Council was at pains in Thomas and Batiste to say that they were not questioning that principle. What I understand them to have been saying was that they were applying a principle recognized by the common law in a very narrow area that, put it in terms of the death penalty case, you ought not to execute someone without allowing them to complete the process which you allowed them to start in the first instance. in order to persuade you not to execute them.
Yeah, but with respect, the Privy Council juxtaposed two postulates. Immediately after saying what you said, they went on to say by ratifying a treaty, the executive for the time being,
Yes.
temporarily,
Yes. Temporarily.
amended the due process provisions of the Constitution. How can you amend the due process provisions of a Constitution temporarily? What are the implications of this? What is the implication for uncertainty in the law?
Your Honor, that constitutional rights derived from executive acts is not unusual. In Thornhill and the Attorney General, for example, it has been accepted that rights that are that would be enforced under the Constitution may have been derived from executive practice prior to the Constitution. And that also has been, that is just simply part of the constitutional law of the region. So it's not unusual that rights can derive from executive acts. That's the first thing I would say. In this particular instance, what I understand the Privy Council to be saying, and I'm conscious that I'm trespassing on Mr. Shepherd's territory at this point in time. What the Privy Council is saying is that in this particular, we're not incorporating the treaty as such. We're not saying that you are bound by any recommendation of the Commission or the court, as the case may be. We are saying that having represented to a condemned prisoner that you can go to the court or the Commission to get an opinion which might influence us as to whether you should be executed or not, it is unfair to execute the person while that petition is pending. And it is in that limited sense that the treaty, as it were, is incorporated into the law, the domestic law.
I was about to ask you, Mr. Mendes, do you know of any instances where the recommendations of the international court has influenced in a favorable manner the carrying out of the death penalty?
Your Honor, that is a difficult question to answer because there are occasions where there are commutations, and coincidentally there's a recommendation of commutation, but I don't know of any situation where the state has actually said we are commuting because of a recommendation made by the Commission. As a matter of fact, certainly my experience is limited really to Trinidad, and the state never ever says that they are following a recommendation, although ultimately they may do sometime later on what the Commission has in fact recommended.
So really speaking, the recommendations are, you can say, invariably not followed.
I don't know. That's what I'm trying to say. I don't know.
But have you, are there cases in which a person who is under sentence of death has applied to the Commission for a recommendation that he be not executed, and the Commission has declined to make that recommendation? Sorry?
I would have to research that, Your Honor.
Because I really don't know. I mean, no disrespect to the Commission, but I was under the impression that there invariably they would not countenance the carrying out of the death penalty on anyone. Am I wrong? Or?
I don't know.
You don't know.
I can try and find out, Your Honors, and do some research, and maybe, if you wish.
You know, I mean, there is you talk about there not being coming as a surprise that the Frederickson Benny was overruled and so on, and I understand that, you know, and I think that there is an understandable disposition, use that word, to extending the opportunities for a man to avoid the execution.
Yes.
And particularly when it comes to things like giving him a hearing.
Yes.
And making sure that the process is fair to him, even in relation to the grant of mercy. But, you know, I wonder whether in practical terms, as I've said, this appeal to the to these foreign bodies which are committed to oppose the carrying out of the death penalty in every case, whether in practical terms they really provide much assistance, much prospect of affecting the decision of the advisory committee or the Barbados Privy Council.
Your Honor, may I answer?
I don't know that they are necessarily going to be impressed. But something which hasn't been considered to be a breach of domestic law is going to be considered by this foreign body to be a breach of international law. I somehow suspect that these committees, be they the BPC or the advisory committee or what, are not overly concerned about whether the government is or is not in breach of their international obligation.
Your Honors, if I can answer your question or respond to your observation in this way, I don't think that either of us know, at the end of the day, the extent to which any particular board of the Barbados Privy Council will respond to a decision of the Commission. We simply do not know. The question that I'm raising as to whether you should not follow Lewis is that you should take into account that that the rule in Lewis is giving the condemned man an opportunity, a further ammunition by which he can persuade the Barbados Privy Council. Now, I do not know, and I don't think anyone can say, that there will not be a case where there is discovered during the course of the process of the petition before the Commission a violation of rights that does in fact impress the Privy Council, the Barbados Privy Council, and does in fact result in them deciding to commute the death sentence. There may be we are not aware of any particular case because they don't tell us exactly what has influenced the decision one way or the other. So we don't know the extent to which decisions in the past have influenced their decision whether to grant mercy or not. But certainly the mere existence of the possibility that a decision of the Commission might influence them is sufficient, I would respectfully submit, to hold on to the rule that would require the state, the Crown in Barbados, not to execute until the full opportunity is given to obtain such a provision.
Well, you see, that would be fine, but for the fact that at the same time you are giving the foreign body the opportunity to frustrate the carrying out of a punishment which is mandated by your own law.
Now, that is one of the final points that I wanted to address as to the question, or that observation, I think, falls into the area whether the rule in Lewis is causing any serious disruption in the administration of criminal justice, whether it is causing any injustice to anyone. Certainly it's not causing any injustice to any prisoner on death row. It may be said that the requirement that you go before an international body is creating a situation where persons on death row may be able to rely on the Pratt and Morgan decision. Now, there are two answers to that I would respectfully submit. First of all, in Barbados, for persons convicted of murder after the amendment in 2002, the Pratt and Morgan rule simply does not apply anymore. And in addition, the Governor General under the Constitution is now empowered to limit the time for petitioning to the Commission, so that the continuation of the Lewis rule in Barbados is not going to cause that sort of injustice. In relation to persons to whom the Pratt and Morgan rule still applies, which would be a minority of persons, I'm informed, this court can say that whereas you will follow Lewis, even though you think it is wrong, nevertheless, appropriate adjustments would be made to the Pratt and Morgan rule, as suggested in, I believe it is Thomas and Batiste, either by saying that, well, I think there's only one way that this court can do it, that is to say, to discount delay before the international bodies that the court considers to be unreasonable. So in other words, if that involves an extension of the 5-year period, as I think Your Honor pointed out earlier to my little friend, that the Privy Council said that the 5-year period is a guideline, and you'll have to view that in all of the circumstances of the case. So that if the proceedings before the Commission is simply taking too long, and there's no good reason for it, then you would not be able to lay that delay at the door of the state and say that as a consequence it cannot carry out the death penalty. So respectfully submit that
the trouble with that, and a point which I adverted to in Thomas and Batiste, is that the only way of knowing whether or not it is constitutional to carry out the death penalty is to read the warrant, which then galvanizes the prisoner or his legal advisors into action. And then you have the whole process of litigation through the three tiers of courts. And in that case, I regretted that there wasn't the possibility of the Attorney General coming to the court for a declaration that it was in order for the death penalty to be carried out on a particular prisoner.
Yes.
And it could be done in a more orderly fashion rather than have all this crisis situation and, stays of execution in the middle of the night and all of that. And then.
Well, Your Honors, we on this side certainly are very well aware of the trauma that occurs.
Well, I'm sure.
And we have made very many efforts.
That unfortunate man who we all know about, who was hanged in Trinidad while they were doing and froing between the Privy Council and the Court of Appeal.
Yeah. Yes, these things have taken place in the past. As far as the particular rule is concerned, certainly for Barbados, they have the wherewithal to make it certain by publishing rules dealing with the timelines that one has to make these petitions to the international bodies. So that uncertainty can be easily removed. The point I'm making is that there is no basis for saying that it would be unjust to continue the rule in Lewis. It's not unjust to anyone to continue it. I would respectfully submit it would be unjust to condemn persons to not continue the rule, particularly since the Parliament of Barbados has thought it fit to provide the mechanism whereby the situation can be made certain. Lewis, in other words, in Barbados, is not causing any disruption to the legal system at all. It has been adequately accommodated by Parliament. It would be awkward, if I may put it this way, for your honors to say that you will not follow Lewis, that Lewis is not the law in Barbados, when Parliament recognized it as law and made provision in the Constitution to cater for it. And that, among all the reasons, I think is I respectfully submit, one of the more compelling reasons why your honors ought not to depart from Lewis in the event that you are not persuaded by Mr. Shepherd that Lewis was in fact rightly decided. Unless I can assist you with anything else, your honors, those are my respects.
Thank you, Mr. Mendez.
Much obliged.
Mr. Shepherd.
Thank you, Your Honor. I should like to open the arguments, Your Honors, on the Constitutional Amendment Act 2002. And that can be found in tab 6 of volume 2 of the appellant's bundles. I think one of the questions that was asked or that ought to be addressed is the question as to whether Section 5 of that Act applies to anyone other than the respondents in this case. And I think the answer to that is no. But of course, I cannot speak beyond peradventure, and perhaps my learned friend Mr. Ford, who appears for the Crown, can take instructions on that. But that is my understanding.
What's that?
That the Section 5, Your Honor, in other words, the Section 5 which reads this amendment made by Section 2, Section 15 of the Constitution does not apply in relation to a person on whom the sentence of death was pronounced before the coming into operation of this Act. I do not think that that applies to anybody other than the respondents in this case. The point about that, Your Honours, is that that amendment in Section 2 is the amendment which precludes a challenge to the carrying out of the death penalty on grounds of delay. In other words, it disapplies Pratt in relation to Barbados. So the application of the time guidelines in Pratt are only relevant to this case. Now that is my recollection, but of course I have to say, Your Honours, that I'm not deeply involved in the practice of criminal law, and therefore I may be wrong. But that is my understanding. In other words, these are the only persons on death row that can take the benefit of Pratt. Now, Your Honours, in Section 2, subsection C, that reads, the holding of any person who is in prison or otherwise lawfully detained pending execution of a sentence of death imposed on that person in conditions or under arrangements which immediately before the coming into operation of the Constitution Amendment Act were prescribed by or under the Prisons Act as then in force or were otherwise practiced in Barbados. That effectively prevents an argument on prison conditions. Section 3 of the Constitutional Amendment Act is, I don't think, applicable to the case before your Honours. And then Section 4 is the important one. Section 78 of the Constitution is amended by adding the following sections. A person has a right to submit directly or through a legal or other representative written representations in relation to the exercise by the Governor-General or the Privy Council of any of their respective functions under this section, but is not entitled to an oral hearing. Excuse me. 6. The Governor-General, acting in accordance with the advice of the Privy Council, may by instrument under the public seal direct that there shall be time limits within which persons referred to in subsection 1 may appeal to or consult any person or body of persons other than Her Majesty in Council outside Barbados in relation to the offence in question, and where a time limit that applies in the case of a person by reason of such direction has expired, the Governor-General and the Privy Council may exercise their respective functions under this section in relation to that person, notwithstanding that such an appeal or consultation as aforesaid relating to that person has not been concluded. And then 7 says, nothing contained in subsection 6 shall be construed as being inconsistent with the right referred to in paragraph C of section 11. It is therefore your respondent's submission that the effect of the constitutional amendment is to disapply Pratt and to give to persons convicted of murder and sentenced to death in Barbados a right to proceed to the international bodies or courts within timelines that the Governor-General may or may not choose to implement, and that once that process has been completed, however long it takes, the sentence of the court can be carried out. So the rush and what I would call well, it is a right to get within the timelines as set in Pratt and Morgan are no longer an issue. And those are now entrenched in the Barbados Constitution. More importantly, I think, Your Honours, is the fact that subsection 7 refers specifically to section 11, which has been often termed the declaratory section. And it is, in my submission, addressing a right under the Constitution, which section 6 and section 7 proceed on the presumption that they are enforceable. So the competing interests of the Crown and your respondents that arise out of the decisions of Pratt and the decisions of Lewis are no longer applicable according to the Constitutional Amendment Act. So it would appear to me, Your Honours, that this strengthens our point, and together with the concession this morning from Counsel for the Crown as to the delay period, that the issues raised in this appeal are of great academic importance, but cannot in our submission result in a revisiting of the death sentence upon your respondents. Now, my lords, having opened on that, I should like to turn to the troubling question which I think your lordships stressed, that is the Lewis case and the Thomas and Baptiste and the overruling. Excuse me, my lord. And I now turn, my lords, to volume 1 of the respondents' bundles, of the appellants' bundles. Now, Your Honours, I had intended to take your Honours back directly, but I think it's probably more appropriate, in light of the questions that were asked, to take Your Honours to the case of Higgs. And that, I think, is at tab 14 of the appellants' bundles, volume 1. In my submission, the important dicta in Higgs is at it begins at page 20. Of the decision of Lord Hoffman. Where he addresses the effect of Thomas and Baptiste. It is my submission that Lord Hoffman clearly accepted the general right created by the Convention was given effect in the common law. And I think that that can be found at page 21 when he addresses the decision of Lord Millet.
What letter?
It is letter G to H, Your Honour. Where he cites the decision of Lord Millet in Thomas and Baptiste, the right for which the appellants contend is not the particular right to petition the Commission or even to complete the particular process which they initiated when they lodged their petitions. It is a general right accorded to all litigants not to have the outcome of any pending appellate or other legal process preempted by executive action. This general right is not created by the Convention. It is accorded by the common law and affirmed by Section 4A of the Constitution. The appellants are not seeking to enforce the terms of an unincorporated treaty, but a provision of the domestic law of Trinidad and Tobago contained in the Constitution. And then Lord Hoffman goes on, so far this reasoning still did not explain why, apart from the Republic's treaty obligations, the petition to the Commission should be a pending appellate or other legal process when an appeal to the Human Rights Watch or Amnesty International would not be. The answer was given at page 422 in the very next sentence. And that's turning to page 22. By ratifying a treaty which provides for individual access to an international body, the government made that process for the time being part of the domestic criminal system, justice system, and thereby temporarily at least extended the scope of the due process clause in the Constitution. It therefore appears to their lordships that the ratio decidendi of Thomas is that the due process clause in 4A of the Trinidad and Tobago Constitution gave the Crown power to accept an international jurisdiction as part of the domestic criminal justice system. It was on this ground that Lord Millett distinguished Fisher No. 2. Their lordships note that a similar argument was rejected by Fisher. They observe, however, that the Constitution of the Bahamas, which was under consideration in that case, does not include a due process clause, similar to that contained in 4A of the Constitution of Trinidad and Tobago. And then the board in Thomas and Baptiste did not therefore cast doubt on the correctness of Fisher, the ground upon which the minority had dissented in that case, namely that execution during dependency and so on. Now, my lords, Lord Hoffman says at letter G on the same page 22, their lordships have no difficulty in making this implication of the ordinary common law concept of due process as being in accordance with law and general principles of fairness. But the majority of the board in Thomas clearly did not regard this common law concept as having the power, absent specific language in the Constitution, to incorporate procedures having an existence only under international law into the domestic criminal system. That, as I understand it, Lord Hoffman's understanding of Fisher, of Thomas and Baptiste. He then goes on, Your Honours, at page 23, letter B, to refer to Lewis and the Attorney General, which would have been the Court of Appeal decision in Jamaica. And he says reference was made to the recent decision of Lewis, which contains an interesting discussion of the relationship between Fisher No. 2 and Thomas and Baptiste. But since an appeal to the Privy Council in that case is pending, their lordships think that it would be inappropriate to comment on the judgment. For the sake of completeness, Your Honours, he then goes on, for the sake of completeness, their lordships note that there are grounds for saying that even if this appeal was from Trinidad and Tobago, the claim that execution before the decision of the Commission was unconstitutional might well fail. Firstly, as already noted, Lord Millett accepted that the government would have had the right to stipulate for an 18-month time limit on the petition process. Secondly, Lord Millett laid stress upon the fact that the appellant's petitions to the Commission complain not only of the carrying out of the sentences, which would have been a matter for the non-justiciable procedures of the advisory committee, but also of the fairness. He repeated this point in Briggs, and the presently no complaint is made about the fairness of the trials. So, Your Honours, Lord Hoffman explains and does not think that Thomas and Baptiste conflicts in any way with Fisher.
But he was wrong, wasn't he?
Yes, I think so, my lord. I think so, Your Honor. I don't.
But it's fairly obvious that if he didn't think so, he would might have expressed his disagreement with him.
Let us assume, Your Honor, that that is correct. But my point simply is that Lord Hoffman was saying, as I understand it, that he understood the decision in Thomas and Baptiste to be that the court could only incorporate the common law concept of fairness by a due process clause and not by a protection of the law clause. That is, as I understand what Lord Hoffman is saying. He comes to the conclusion that Thomas and Baptiste says that you cannot do it by virtue of a protection of the law clause. And to some extent, I would have to regard that as obiter. And also, it appears to me that he does not in any way examine that in any great detail because he is aware of the fact that Lewis is pending before the Judicial Committee of the Privy Council.
Yes, Mr. Shepherd, it's interesting that he doesn't look at Section 4 of the Trinidad and Tobago Constitution because that sets out separately from the due process of the law protection of the law. They're regarded as two distinct concepts under the Trinidad and Tobago Constitution.
And I think it's a sort of basic rule in drafting counsel that draftsmen do not use different terms to convey similar meaning.
Your Honor, I accept that in relation to drafting of statutes. But in view of the fact that the courts have regarded constitutions as sui generis and taken a completely different approach to their interpretation, I think that that must necessarily inform, surely, the draftsman. And there would not necessarily be the same reliance or the same thought process in the drafting of a constitution as opposed to an ordinary municipal law.
Yeah, but I think the 14th Amendment of the United States Constitution also uses due process and protection of the law in the same line, in two discrete senses.
So now your Honor is taking me to this argument, due process protection of the law. If I can address that in this way, I think that one has to now go back to Thomas and Baptiste and Lord Millet's judgment. And that, my lords, is in the same bundle at tab 16. Now, my lords, and if I can take your lordships to page 422, letter E. And that, I think, at letter E, where Lord Millet says, in their lordships' view, the appellant's claim does not infringe the principle which the government invokes. The right for which they contend is not the particular right to petition the IACHR, or even to complete the particular process which they initiated when they lodged the petitions. It is the general right accorded to all litigants not to have the outcome of any pending appellate or other legal process preempted by executive action. This general right is not created by the Convention, it is accorded by the common law and affirmed by 4A of the Constitution. The appellants are not seeking to enforce the terms of an unincorporated treaty, but a provision of the domestic law of Trinidad and Tobago contained in the Constitution by ratifying a treaty which provides for individual access to an international body. The government made that process for the time being part of the domestic criminal justice system and thereby temporarily at least extended the scope of the due process clause in the Constitution. Their Lordships note that a similar argument was rejected in Fisher. They observe, however, that the Constitution of the Bahamas, which was under consideration in that case, does not include a due process clause similar to that contained in 4A of the Constitution of Trinidad and Tobago. It seems to me, Your Honours, that it is upon that basis that Lord Hoffman in Higgs is concluding that Thomas and Baptiste's position was that you could not incorporate that common law proposition absent a constitutional provision.
To that effect?
It is what I would submit, my lords, is that I am not sure I agree that that is what their lordships are saying in Thomas and Baptiste. It appears to me that what their lordships are saying is that they are going to imply it through due process. And again, the reference to Fisher would be obiter. And putting it simply, they say we're not taking it on at this time.
But they didn't confront the fact that they were overruling Fisher.
I accept that, Your Honour, and
which is a pity.
Well, I think that can be explained by the fact that the board presumably would have been sensitive to the fact that it was sitting as a highest court of appeal in Thomas and Baptiste on an appeal from Trinidad. And to that extent, they may not have wanted to make binding pronouncements in relation to the Constitution of the Bahamas. And therefore, the statement at letter J upon which Lord Hoffman relies.
They made out that there was a difference between the two provisions. And that was the explanation of why they could decide as they did without overruling Fisher.
Yes, Your Honor.
They now turn around in Lewis and say, but that's a distinction. That's a difference without a distinction without a difference.
I think, and they say that principally having addressed the arguments which were put forward in Lewis on the differences between the various constitutions, and they say, as I recall in Lewis, while we don't think that those submissions are untenable, we don't want to arrive at the decision on that basis. We would rather, and I put it in layman's terms, have a decision which guides all of the Caribbean territories' constitutions. But to a large extent, it would be my submission that the difference between due process and protection of the law is more semantics than anything else.
There is the problem. You've got these two apparently different concepts in the Trinidad and Tobago Constitution. So it seems to me what Lord Hoffman was offering in the Higgs case was a compromise solution whereby they'd accept Thomas and Baptiste as an anomalous exception to international law, not indirectly being enforceable in domestic law, and he hoped the line would be held there. However, he was exasperated, I think, in Lewis, as appears in his minority dissent, that the line wasn't held there, and he was trying to keep a balance between the two opposing camps. But I mean, albeit this is very interesting, of course, we ourselves can come to our own conclusion in this area where clearly there are very divergent views.
And of course, my lords, in that regard, your lordships may take some comfort in the fact that in the Court of Appeal in Barbados, in Harewood, it is, sorry, it's not the Court of Appeal, in the High Court in Barbados, in the case of Marshal and Harewood, it was not appealed, where Mr. Justice Husbands, that would be tab 18 of volume 1 of your respondents' bundle.
I know it is respondent. Yes.
At page 13, Your Honours. I'm sorry, Your Honours. It starts at page 12, the bottom of page 12. Mr. Shepherd submitted that a condemned man therefore acquired the right to have a sentence reviewed by the Privy Council in Barbados. In effect, therefore, this process of consideration by the Privy Council, whether to commute or not, is in essence similar to the sentencing function of a judge in a criminal case, and therefore has judicial characteristics. He referred to Bentley. The above is authority for the submission that the courts now recognize that there is jurisdiction to review the exercise of prerogative of mercy. The dicta of De Freitas and Bentley cannot be used to support a submission that the exercise of the royal prerogative of mercy cannot be the subject of judicial review. The dicta in Riley and the AG must be read against the background of Bentley, in that Bentley has taken the law further. In Riley, the judges seem to be saying that the condemned man had a de facto right to the proper exercise of the prerogative of mercy, for which a remedy existed if the exercise amounted to an infringement of the protective provisions. Therefore, applicant had a de facto right to the proper exercise of the powers of pardon as set out in section 78 of the Constitution, and in the event there was an infringement of provisions of sections 11 to 23 by the exercise of those powers, section 24 provides the remedy. And then he goes on to consider Abbott, Doody,
What did this case decide in a sentence?
There was a commutation, and if I can take your lordships then to, well, there, the page is at page 8. It's marked up at the top at 341. Thomas Reckley revised and supports the decision of these forms. The tenants are therefore not entitled to the release. So he applies Reckley And then, my lords, he commuted on Pratt and Morgan principles.
We're going to have to take the lunch break now, Mr. Shepherd. So we will rise now and we will resume at 1:45.
Thank you.
An hour's time.
All right.
Mr. Shepherd, you resume.
Your Honor, I was simply just before we rose, making the point that, for what it is worth, that is in the High Court, Mr. Justice Carvey Husbands felt that what was preventing him from reviewing were the cases of Reckley and De Freitas and Benny. And with that observation in mind, my lords, I'd like to take your lordships to the case of Lewis and others, and that is at tab 1, your honors, at volume 1 of the appellant's list of authorities. Volume 1.
The appellants? The appellants?
Yes, Your Honor. As I understand it, Your Honors, this court is aware of the fact that there were interveners in Lewis. And we know that Barbados did not intervene. But it is your respondent's submission that Barbados regarded itself properly as bound by Lewis. Certainly, the board would have had the benefit of arguments in relation to the different formats of the Constitution.
Do you know if Barbados was invited to intervene? Or?
I think my understanding is put rather this way. As far as I'm aware, Barbados was aware of the fact that the other countries were intervening. I am unaware as to whether those interventions were by way of invitation or on their own initiative. I rather think that it was on their own initiative. And I think properly put, the position is that Barbados was aware of the option, but did not seek to intervene. Your Honor, there is one correction I'd like to make. I was reminded during the break that there is one prisoner who may fall within the exception in the amendment, and that is a prisoner by the name of Huggins. But it is our understanding that the 5-year period has now elapsed in relation to his conviction.
Is that MacDonald Huggins? Is it?
Michael, I think, Your Honor.
Michael.
Michael Huggins. I have already drawn Your Honor's attention to the dicta at page 291 at letter F, which simply says these differences have been forcefully put before the board, but without going so far as to say that the argument that these differences distinguish the present case from De Freitas and Benny and Reckley are untenable, as Justice of Appeal Donner considered in the case of Patrick Taylor, MacLeod and Brown, their lordships do not consider that the differences justify a distinction being drawn in this regard between the three countries. I think it is correct to say, Your Honours, that Lewis is the first time that the format adopted in the Bahamas Constitution is being addressed after Baptiste. And I have already drawn Your Honour's attention to the what I regarded to be the obiter. Your Lordships will see that page 292, letter H, there is reference to the fair play in action principle. And thereafter there is reliance on Thomas and Baptiste. And if I can take Your Lordships to page 299, where the judgment of Justice of Appeal Fort is quoted, in particular at page 300, letter B to C, where Justice of Appeal Fort says, in my opinion, the two terms are synonymous, and consequently, as in Trinidad and Tobago, the people of Jamaica, through the protection of the law guaranteed in Section 13 of the Jamaica Constitution, are endowed with constitutional protection to the concept of procedural fairness. And I merely mention that as Section 13 of the Jamaica Constitution is the equivalent of our Section 11, and the Section 13 of the Jamaica Constitution is not mentioned in their enforcement provision, similar to the position in Barbados. And then their lordships go on at page 303, letter B, to say, their lordships do not consider that it is right to distinguish between a constitution which does not have a reference to due process of law, but does have a reference to the protection of the law. Your Honours, for what it is worth, we do have for the court a full copy of the Jamaica decision in Lewis, and that is to be found at volume 3, I believe, of your respondents bundle. At tab 20. Again, for what it is worth, I draw your lordship's attention to page 248 of that decision, where there is, it is in the decision of Justice of Appeal Downer. letter B at page 248. With respect to Chief Justice Wolf, the issue was not the sovereignty of Jamaica. The Jamaica government had withdrawn from the optional protocol and could, if it wished, denounce the convention relating to Inter-American Commission on Human Rights. The point to note is that the ministry paper dated 28th October, exhibited by the appellant, demonstrated that the executive saw the need to conform to Pratt, the Attorney General, and that prompted the withdrawal. 3 paragraphs from the ministry paper make that clear. The government of Jamaica decided to withdraw from the optional protocol as a result of the ruling of the Judicial Committee of the Privy Council in the case of Pratt. The government of Jamaica is in no way resiling from its hallowed observance of the due process of law. The right to a fair trial and to the protection of persons from inhuman, cruel, and degrading treatment. These are provided for in our Constitution. I merely draw that to your Honour's attention for the purpose of demonstrating that certainly it would appear that the government of Jamaica was equating due process with protection. And then there is the case of Khan and Trinidad, and that is at tab 26 of your respondents bundle, volume 2.
Volume 3.
It must be, yes, volume 3. I am sorry, Your Honor. Where no distinction was drawn between due process and the protection of the law. This is not the right. I shall have to find the exact reference of that for Your Honours. I have the wrong. I should have to find that exactly, my lords. Sorry, Your Honour. Now, essentially, Your Honours, the submission of your respondent is that if there was any aberration in the law, it would appear to us to emerge from the cases of Fisher and Higgs, and that the cases of Batiste and Lewis represent a logical development of the law in relation to judicial review of executive action. Your Honours, in this regard, I should like to refer the court to the decision of Onga Chan. And that, I think, is a decision, I do not think that at the moment Your Honours have a copy of that case. We have a copy for you.
Singapore. Mr. Chabad, going back to Khan, at paragraph 9, I think that's where they refer to the due process of law phrase and the protection of the law. And it seems that all that happened there was that counsel never questioned that there was any difference. and proceeded from that point. So it doesn't help us, does it?
Well, insofar as the decision itself doesn't take issue with it either, with that acceptance.
Yeah, but you may recall, Counsel, that President Ford, in suggesting that due process and protection of the law were synonymous,
Yes.
he adduced no reasons for so saying. He blandly made this statement of fact. And the Privy Council jumped in it in the Lewis case. No reason at all was adduced for so doing.
Well, Your Honor, I myself would have some difficulty in developing a jurisprudence that centered upon trying to distinguish between the two phrases. It is, in my submission, almost akin to different routes for arriving at the same conclusion. They are terms which are used by constitutional framers in order to enshrine rights of fairness. I don't know that there is any way that one can distinguish between due process and protection of the law in such a way so as to say, yes, if you have due process, you will get that right. But if you have protection of the law, you're out in the cold. And the only case in which it seems to have come forward is in respect of this, of the effect one gives to the rights of condemned prisoners to prosecute petitions to international bodies. And the only reason why it arises in those cases is because of the particular nature of the penalty. It wouldn't arise in any other case. It would, oh, sorry.
Counsel, I will certainly concede that the two concepts are complementary. That protection of the law simply sort of gives you a range of avenues through which due process can be secured. But to say the two things are synonymous, I think is a bit too much to accept.
Well, if I understand your Lordship, Mr. Justice Pollard, to be saying that due process is not as wide as the protection of the law, in that due process is a way of achieving protection of the law, then I would suggest that the difference is between the two doesn't turn, nothing in this case would turn on that difference.
No, the opposite actually.
Well, then
protection of the law is the means employed to achieve or secure due process of the law.
So due process is wider than protection of the law. But I would have two difficulties with that. The first difficulty I would have is that I was reminded, we do not have a copy of the decision. For this I do apologize, but I was reminded during the break by my friend Mr. Mendez that in the case of Rees and Crane, within the Trinidad Constitution, your right to due process only arises in relation to life, liberty, and security of the person. Protection of the law encompasses other rights. And that was, I was reminded, was more or less the decision in Reason Crane, where reliance was made on protection of the law as opposed to due process. Now, that would suggest to me that protection of the law, if anything at all, is wider. But at least the equivalent.
You say that protection of the law includes due process.
I
It's a wider concept of which due process
is a part of, if there is any distinction to be made. But I would not invite Your Honours to make a distinction in this case, because I don't think that anything turns on that.
My own understanding, Counsel, is that due process and rule of law are more synonymous than due process and protection of the law. Rule of law or due process goes to the rule of law, right? And protection of the law are all those things which the law sees the citizen as being entitled to in order to secure due process.
Am I correct in saying that what Your Honour is suggesting, that protection of the law reads more or less protection of the municipal law, domestic law, and therefore to that extent it would not include any rights at all under any international law?
And that is clearly axiomatic.
But then,
Insofar as due process of the law could only refer to due process of the law of the state concerned, not of a completely different regime of law. International law is a separate sort of regime from municipal law. And to bridge that gap, as the Privy Council tried to do in Thomas and Matisse and Lewis, I think is somewhat too much to accept.
but, Your Honour, in answer to that, I would say that municipal law includes common law. And the common law has now been pronounced to include a right in the case of death penalty matters to the benefit of the process, the legal process, through the international bodies.
But only if you can establish that that international process is a part of customary international law, which is a part of the common law, but not into the treaty law, a qualitatively different thing.
Certainly, I think the proposition that the common law encompasses that is to be found in the cases. And I do not understand Lord Hoffman to be saying otherwise. What I understood was being said is, if it is in the common law, you cannot bring it into your constitution absent some specific provision. And in Trinidad, you have it by way of a specific provision in due process. But the common law is there. It is common law.
Yeah.
The question is whether you can bring it in, to elevate it, as it were, into a constitutional proposition. And the view was that you could only do that, let us say, under due process. But if you are incorporating protection of the law, if you are including in your definition of protection of the law, then you also bring it into the Constitution through common law, common municipal law.
Yeah, but how do you now go on to incorporate the international aspect of the appeal process
through the common
into
law.
your municipal law, unless you can establish that international appeal process is a part of customary law, which is a part of your common law. But
then,
usually, customary international law can issue from treaty law. But we are thinking here now of treaties, the Convention on Human Rights, and those are not incorporated automatically into the common law. Customary international law is not treaty law, and that is a qualitative difference with respect, Counsel.
so then it seems to me that Your Honor is challenging the finding or the pronouncement that the right that a person on death row has, that that he can't be preempted in any way from pursuing his remedies under the treaties, if we call it that, is a part of the common law. That is the proposition that Your Honor is attacking. You are not accepting, it seems to me, the dicta insofar as it says that that right is part of the common law.
The question is not whether there is a common law rule about not interrupting legal process. The question is as to the extent of that rule, as to whether legal process extends to a process that exists only under international law.
But I was under the...
That is where the Lord Hoffman parts company with his colleagues on the Judicial Committee. And there's no point in insisting that there is in the common law a rule against interrupting legal process. That is not in dispute. The point is whether it is permissible to add the phrase analogous legal process and treat that as embracing the applications to the Commission.
If I could just
That
add,
is the issue.
if I could just add something to that, you are able to do that, you reckon, by using this expression, the prevention of the law, as affording the constitutional right. But of course, one must look at the definition section of law, and section 117 of the Barbados Constitution speaks of law including any instrument having the force of law, and international treaties don't have the force of law unless you've got a statute that says the convention and the schedule hereto shall have the force of law as from such a date. That's the normal way to do it. So it only covers any instrument having the force of law and any unwritten rule of law. I don't think there's any scope for that.
Well, Your Honor, I think that depends again on the interpretation of the word law.
Yes.
Yes, and well, what's the prima
Why
facie
can we
meaning?
not read international law?
It's in front of the
Well, I thought prima facie, any instrument having the force of law means having the force of law under Barbados domestic law.
Well, why can't it read, Your Honor, having the force of international law?
Well, I mean, that goes totally against all the common law understanding of sanctions.
So the Constitution doesn't provide for international law.
I'm sorry, ma'am.
The Constitution under which law is interpreted and defined does not provide for international law.
So I accept that. I accept it. I wonder if I can just get a copy of...
So it must relate only to the municipal law.
So it's tab 1 of Appellants, volume 2.
I'm just going to the Constitution. Your Honor is taking me to section
117.
The wording is includes, so it can be other than. and it would certainly include common law.
Yes, that's the unwritten rule of law.
Yes.
Specifically mentioned.
So are we not back to whether the common law encompasses the right that we seek? And I was under the, it would be my view, that in Lewis, what they were saying was that that is the common law for Barbados.
But I thought the position was that it was only by virtue of the expression due process or the prevention of the law, the protection of the law. It's only by using those phrases that you can mediate between the strict rules separating international law from domestic law. So we've got to look at these terms, due process, and the protection of the law to see if it gives an escape route from the clear separation that otherwise exists between international law and domestic law.
The common law knows nothing about the Inter-American Commission. Doesn't speak to it at all.
I was just going back, Your Honor, to Lord Hoffman's decision in Higgs. Now, and I'm going back, Your Honours, to page 21 of Lord Hoffman's decision in Higgs.
We found it.
Which volume is that, Mr. Shepherd?
It is volume 1 of the appellant's bundles. At tab 14. Tab 14.
14.
First of all, Your Honours, at page 21, letter G, Lord Hoffman refers to the right in citing the judgment of Lord Millet. The right for which the appellants contend is not the particular right to petition the Commission or even to complete the particular process which they initiated when they launched their petition. It is the general right according to all litigants not to have the outcome of any pending appellate or other legal process preempted by executive action. This general right is not created by the Convention. It is accorded by the common law and affirmed by Section 4A. The appellants are not seeking to enforce the terms of an unincorporated but a provision of the domestic law. So far, this reasoning still did not explain why, apart from the Republic's treaty obligations, the petition to the Commission should be pending appellate or other process when an appeal to the Human Rights Watch and Amnesty International would not be. But the answer was given in the very next sentence. By ratifying the treaty, which provides for individual access to an international body, the government made that process for the time being part of the domestic criminal justice system, and thereby, temporarily at least, extended the scope of due process. I submit that there are two steps here. My understanding, and this is my submission, that the right not to have your legal process preempted by executive action is a common law right, and that common law right is extended to individual access to an international body. That is a common law right.
But with respect, it only gives you an individual right where you have some pending appellate or other legal process. And if you've gone on to complete the quote, I think on page 22, it says, it therefore appears to their lordship that the ratio des adendi of Thomas and Baptiste is that the due process clause in section 4A of the Trinidad and Tobago Constitution gave the Crown power to accept an international jurisdiction as part of the domestic criminal system. So you have that common law approach, not to have matters preempted in respect of a judicial or legal process. What makes it a legal process is the due process clause in the Constitution, not the common law. And that is actually spelled out lower down, I think, in page 22, paragraph H. But the majority of the board in Thomas clearly did not regard the common law concept as having the power, absent specific language in the Constitution, to incorporate procedures having existence only under international law into the domestic criminal justice system. So surely the point being made is it's these words, due process, or in the Neville Lewis case, protection of the law alone that makes this some sort of part of the legal process, so as to get the benefit of the earlier common law rule you mentioned.
That what we say, Your Honor, is that what Thomas and Baptiste says is that the common law embraces that right, and in constitutions that have due process, it is a constitutional right. Question whether, in relation to the protection of the law, constitutions, that is also a constitutional right.
Yes, but I think, Mr. Shepherd, the key thing is you've got to have this specific language, due process or protection of the law, as emphasized at paragraph H.
I'm sorry, I think that the difference between us lies in where you draw the line. You see, it is our submission that what they were saying in Thomas and Baptiste is that the common law is there. You have the right under the common law.
But saying it doesn't make it so. What is the authority for saying that the common law prescribes that you have a right to complete an application to the Inter-American Commission? Where in the common law is that to be found?
Your Honor, then the question is different. The question is not directed at challenging whether it is a constitutional right or not. The question goes more deeper than that. It is questioning whether it is even a common law.
This is what I've been questioning from the beginning. That this is the question, the first question.
But, Your Honor, what we say is that Thomas and Baptiste decided that it was a common law right.
I mean, there must be some underpinning for it. That is the philosopher's stone, is it? I mean, we can't go behind it. It's just there.
Well, what we submit, Your Honors, is that that represents the common law of Barbados, given Thomas and Baptiste and Lewis. And it would appear to a reader that the distinction which the board drew in Higgs was not whether it was a common law right, but whether it could be elevated to a constitutional right.
And you must remember that Lord Hoffman was in a difficult position in Higgs. He had to try and avoid coming to the conclusion that his brethren had overruled him without saying so, on the one hand, and on the other, to avoid having to overrule them. So he was really in a corner. And he found a way out via the difference in wording. And then they closed that door on him. subsequently.
Well, Your Honor, what we say is that they closed the door on him, with all respect, rightly so.
Maybe so, but he was looking for a way out. Yes.
My Lord, sorry, Your Honor, if I can take you to the case of Honor Chuang. In the case of Ong Lak Chuang, there was a challenge to the constitutionality of a provision of criminal law. It was taken for the first time before the Judicial Committee of the Privy Council. And their lordships allowed it to be taken and concluded that if they thought that there was some merit in it, they would have remitted it back to the Court of Appeal. But as they decided that there was no merit in it, they dealt with it. And I can take Your Honours to page 865. In the judgment of Lord Diplock. It is the third paragraph, beginning in a constitution, founded on the Westminster model, and particularly in that part of it that purports to assure to all individual citizens the continued enjoyment of fundamental liberties or rights, references to law in such contexts as in accordance with the law, equality before the law, protection of the law, and the like, in their lordships' view, refer to a system of law which incorporates those fundamental rules of natural justice that form part and parcel of the common law of England. That was in operation in Singapore at the commencement of the Constitution. It would have been taken for granted by the makers of the Constitution that the law to which citizens could have recourse for the protection of fundamental liberties assured to him by the Constitution would be a system of law that did not flout those fundamental rules. If it were otherwise, it would be misuse of language, so to speak, of law as something which affords protection for the individual enjoyment of his fundamental liberties, and the purported entrenchment by Article 5 of Article 1 of this little better than mockery. So, Your Honours, clearly the word we submit in any part of the Constitution where the word law is, one reads in the protection of the law and the principles of fairness. And that is addressing, I believe, Your Honour, Mr. Justice Hayton's queries in relation to section 12 of the Constitution of Barbados. Under the law of Barbados. It also, we submit, supports the proposition that there is no difference in relation to protection and due process. Now, Your Honours, there is one aspect of the Interpretation Act. Your Honor, Mr. Justice Labastide mentioned the query as to how one would interpret the amendment. And that is dealt with, I think, in Section 11 of the Interpretation Act. Copies of which we have for your honors. (14) is the relevant section. Which reads in subsection
Pardon me,
2.
could you say what section would you refer to?
Section 14, Your Honor. Subsection 2. An amending enactment shall, so far as consists with the tenor thereof, operate and be construed as part of any enactment which it amends, and without prejudice to subsection 1 of section 13, shall, as from the date on which it comes into operation, have effect accordingly for the purpose of the construction and operation of other enactment which refers to or is incorporated with the enactment which it amends. I think that addresses, Your Honor, Mr. Justice Labastide's question on the effect of the amendment.
Oh.
My Lord, sorry, Your Honors, there is, I think, Your Honor, Mr. Justice Labastide asked of Mr. Mendez the effect of...
Before you pass on, the problem is that my question was really directed to the impact of the amendment on the interpretation of the rest of the Act. This appears, I don't know, first reading to be giving guidance with regard to the interpretation of other enactments rather than the parent act, so to speak. But anyway, I will look at it again, and I'm grateful for the reference.
I must apologize, Your Honor. I was under the impression that what Your Honor wanted was assistance in terms of how one would construe the original sections of the Constitution, given the passage of the amending provision.
Yes, that's right.
And the subsection says, an amending enactment shall, so far as consistent with the tenor thereof, operate and be construed as part of any enactment which it amends.
Yes.
So in substance, our submission is that one would then incorporate those provisions and read the other sections in light of the amending sections. And this is to some extent supported by the fact that the amending act does in fact refer to 11C. And it says of 11C, in my submission, we accept that this is delimiting 7C, but you can't take that into account.
So that one effect of this is that since the news section provides some limitation on the right to have your petition completed before your case is reviewed by the Barbados Privy Council, then that gives rise to an inference that the Section 11C should be interpreted as giving you that right. Is that it?
Yes, Your Honor. And we say that the limitation only arises in the event that the Governor General does in fact pass.
Yes, of course.
Otherwise, you have it right up until the end. You must await the outcome of that process.
And there was some difference, I think, between the Court of Appeal and the parties when they appeared before them as to whether the amending act, the amendments applied to this case.
And both parties proceeded on the basis that they do not.
Is that still the position?
Clearly, in our submission, they do.
Oh.
Yes.
Okay.
Because if I can take you to the amendment came into operation, I think, in early September of 2002, and the warrants, the first warrants, were read to your respondents shortly thereafter. The second warrants were then read in 2004. Now, in 2002, when the first warrants were read, I think the position was that the respondents had in fact been supplied with the materials in accordance with Lewis.
Mr. Shepherd, wasn't the first warrant read in June of 2002, 26th of June? 26th of June.
I'm sorry, yes, your Honor is correct. Just in July of 2000, which is prior.
I think it was read on the 26th of June 2002 for execution on the 2nd of July 2002.
Yes, your Honor is correct. And the commencement date of the amendment is the 5th of September 2002. Yes, yes. My apologies.
So it was well before.
The second warrant.
Yes.
But surely when the Barbados Privy Council considered their case, which was when, presumably, was it before or after the amendment came into force?
They considered it before.
Well, at that time, there was no amendment in force, and therefore the propriety of the BPC dealing with the case of the appellants, of the respondents at that time, would have to be determined by reference to the unamended Constitution.
Your Honor is correct. What in fact occurred was that the first reading of the warrant occurred at a time when your respondents were appealing their criminal convictions to the Judicial Committee of the Privy Council, and stays were granted on that basis. There was dispute, or there was some reliance on the fact that the Crown knew of the matter being prosecuted, as I recall. And
what was the basis on which the, well, I'll ask you about your side, on which the respondents here agreed in the Court of Appeal that the amendment did not apply to them? Or
on the basis that they were convicted prior
yes,
to the coming into operation of the amendment.
but you say that the date on which the sentence was passed is immaterial?
In respect of the review,
Yes.
yes.
In
On the
respect
second
of
warrant.
the application of the amendment.
Yes, in relation to the second warrant.
In relation to what?
There were two warrants that were read.
No. I am talking about in relation to the applicability of the amendment. I am asking whether the date on which sentence was passed, does that not have some relevance to whether that amendment would apply or not?
In my submission, Your Honor, the amendment is directed to addressing the right of your respondents in relation to any challenge they had to the ability of the Crown to execute them.
Yeah.
And therefore, the amendment would apply to the reading of the second warrant.
Well, I am not asking about in reference to this case in particular. I'm asking about it in principle. There is, as far as I know, some sort of presumption against retrospectivity in some cases, anyway. There is nothing in the amending act, as far as I know, which makes it retrospective.
So the question would be whether the amending act confers new rights or seeks to delimit new rights that are there.
Well, on the face of it, it's seeking to delimit rights which it assumes exist.
Yes, Your Honor.
And insofar as its express terms are concerned, it is not favorable to the convicted person insofar as it supposes the existence of a right. It does favor him. But
I think that there was an exchange between Your Honor and counsel for the Crown in relation to the assumptions of Parliament and those assumptions being wrong.
yes,
If the assumption, if the right was not there before, and then therefore this would be seen as conferring new rights, and the retroactiveness of them, the dicta in relation to retroactiveness would not apply. If it was the other way around, then it would apply, and surely in either case your respondents succeed.
well, I don't know. I'm not sure I follow you. What if immediately after the passing of the act, the Governor General had issued documents setting out limitations on the time which the commission would be allowed for sending in their recommendation. And obviously, you could not apply that indefinitely in the past, could you?
No, you could not. I accept that.
Well, what would be the cutoff point or event?
It would, in my submission, be as of the date of the conviction.
Well, there you go.
Over here, should we not look at the times when a right to apply to the BPC arises, the Barbados Privy Council? In that, are you saying that a right to petition the BPC arises after a death warrant has been read out? In which case, we're well after the 5th of September 2002 in respect of the second death warrant. Would you say there's a second right to apply to the governor for clemency at that stage?
The decision in Lewis was prior to the reading of both warrants. So you have Lewis, then you have both warrants, sorry, warrant 1, and then the amendment, and then warrant 2. So the argument, and certainly I think the evidence is that in relation to the first warrant, the respondents were given the materials. And then there was this application. So we would submit that from the date of Lewis, it became applicable to Barbados, and it would have applied to the respondents. And it was applied to the respondents by the Crown, insofar as the materials were given.
Did Lewis come after the amendment or before? Just before?
Before. The Lewis was decided in 2000, and the amendments were in 2002.
So in answer to me, I just want to clear this up. You said the relevant date would be the date of conviction. By that I understand you to be saying that the amendment would only apply to people who were convicted after it came into effect.
If your lordships were of the view that the amendment had the effect of cutting down the rights.
Well, you know, we take it as it is, without making any assumptions about what view we take.
Then
what it clearly says is that limitations or time limits may be imposed. Let us focus on that for the time being. I understand you to be saying in answer to my question that the amendment would only apply to persons who were convicted after the date on which the amendment came into force. Is that right?
Yes, I think that is correct. The amendment.
Well, then it would not apply to these respondents. And your position in the Court of Appeal would be the correct one.
And excuse me, my. Your Honor, as regards, right, let me get my thoughts clear. The decision in Lewis was in 2000, and therefore that decision would apply to anybody in our submission that was convicted prior to Lewis?
Or at any time.
I'm sorry, Your Honor.
Or at any time.
Yes. Insofar as the amendment cuts down those rights, it would be our submission that it only applies to persons who were convicted after its passing.
Well, yes. Well, then it must follow that it doesn't apply to the respondents, and the respondents cannot rely on it.
But they can rely on it, Your Honor.
They can rely on Lewis.
They can rely on it to support the proposition that Lewis represented the law of Barbados from 2000.
Well,
and that the Court of Appeal were correct to apply Lewis.
I have a little difficulty in seeing how an amendment can apply to you for one purpose, but not for another.
For the purpose of construing 11C.
For whatever purpose.
Well, Your Honor, we submit that we can rely on it for the purpose of construing 11C as against the decision in Lewis. And in any event, we think that support can be taken in that because Lewis was properly applied by the Court of Appeal of Barbados for reasons set out in our arguments in the comparison between the sections. We think it is clear that Lewis surely applied to Barbados for reasons that we have explained. What, as I understand the submissions made by counsel for the Crown, it is that Lewis is wrongly decided. I do not know that counsel for the Crown went so far as to submit that it did not apply to Barbados at all.
Lewis?
Lewis. Well, to that extent, we would fall back on our submissions that we put in terms of the comparison between the constitutions.
Yes, of course, yes. Yes. Anyway, we must move on. So,
in the event your lordships, your honours accepted that Lewis did not apply at all to Barbados, then your honour, Mr. Justice Labastide, would have a point.
I never assumed anything on that basis.
I know, Your Honour.
You're now putting something in my mouth which wasn't ever there.
No, what I am saying, Your Honour, is that it would be relevant in the event that Your Honours came to the conclusion that Lewis never applied.
Well, I don't see that. But anyway, let's move on.
Now, there was some questions directed by Your Honour, Mr. Justice Labastide, in relation to the reports from the Inter-American and what possible point they could take up and all the rest of it. There is one argument that did occur to me, and that is that obviously it has been taken up in several instances in cases where the Inter-American Court has decided that mandatory is unconstitutional and only saved by virtue of the provisions. That, I think, is one instance. Not that it necessarily applies to this case, because I think to a large extent, in the case of Joseph and Boyce, that is accepted. In other words, there's an acceptance. So the argument could very well be that's not going to take you any further because they have it in Joseph and Boyce. There is one case in which he has now fallen by the wayside because he died. And that is a case in which the condemned man kept on insisting that he wanted DNA evidence in the face of clear evidence of guilt. I can see a situation where the Inter-American Human Rights Court may very well say that he is entitled to that DNA, and that the Barbados government may decide, well, let us do the DNA testing. And the DNA testing is done, and it is shown conclusively that he is innocent. So I do not accept that they are always worthless. And I can see of situations in which the Inter-American Human Rights Court could play an active role in this process. I do not accept that the Barbados government, in the face of a recommendation, say, from the Inter-American Human Rights Court, that some form of DNA evidence should be done, that the Barbados government would necessarily decline to accept that report.
Mr. Shepherd, could you tell me what is the situation of this particular case in the before the commission?
The actual stage at which it has reached.
Correct.
It is my understanding, Your Honor, that there was an initial petition, that as a result of that petition, a report was made to the Barbados government. We do not see a copy of that report. We get a redacted version of it. The Barbados government is given a certain amount of time in which to respond to that report. And after that time elapses, the Commission decides whether or not the matter should be referred to the court. And the position at the moment is that it is under consideration as to whether the Commission should refer the matter to the court. But I don't think we are aware of the Barbados government's position in relation to any recommendation. We don't know the recommendations, and we don't know their position in relation to it. And I think that is the situation at the moment.
Do you know roughly when the report was made?
So we do have that, Your Honor. When the report was made by the Commission, yes, we do have that. And I will get that for you, Your Honor. I think it is my recollection that I'm sorry. My learned friend, Mr. Ford, is making the point that it's not the final report. That is true. In other words, the report to which I refer is a report from the Commission to the Barbados government. The Barbados government is then given, told what it has to do or what it doesn't have to do or what recommendations are made. It takes a position on that, and as a result of Barbados government's position on that, the Commission decides whether to refer it to the court. And at the moment, the only document that has gone out is the report from the Commission.
Yes.
It's not the final.
What date is that?
And that date.
And
I will get that date for Your Honor.
And did the government react on that?
We do not know, Your Honor. That, as I understand it, is a position taken by the government to the Commission. Oh, I should mention one other thing, Your Honor. That is the report which is made available to us, that is the redacted version made available, is made available to us on the condition that we do not publish it. I should say that. In other words, as I understand the process, it is to facilitate, I'm not saying that it actually happened in this case, but the process is to facilitate a confidential position, Commission and government, that allows the government to rectify anything that the Commission thinks it ought to do. If the government complies, then there is no issue, and its breach is never publicized. So we get the redacted version, but we're not allowed to publish it.
Is what you have described the practice adopted in every case?
Yes, Your Honor. That is my understanding of the practice that is adopted in relation to petitions made by individuals. And it would appear to me that it facilitates a situation where the government is not exposed to a ruling from the court until it has an opportunity to consider a recommendation. Of course, Your Honours are aware of the fact that Barbados has also acceded to the jurisdiction of the Inter-American Human Rights Court. And in that regard, I think we are unique in the Caribbean.
I use the word judgments in quotes. Of that court, are they binding on the state?
In accordance with the treaty, they are. And I can take Your Honour and Justice Bernard to the article in the treaty, which I think is Article 61. But yes, once you accept the jurisdiction of the court, then the article it says that the decision of the court you accept as binding.
So the recommendations of the Commission are not binding.
But the decision of the court is. Now you can discuss whether binding it means binding. In other words, does binding internationally mean binding municipally?
I don't think it does.
And what is the answer?
The answer is, in constitutional terms, binding is binding.
No,
And therefore it is a court. We submit. Your Honours, the article is... Yes, Article 68.
68.
And it is in... It can be found in your respondent bundles, Volume 2, at tab 13.
It's in the form of an undertaking, is it?
Yes.
And 67. Sorry, yes, 68. The state parties undertake to comply with the judgment of the court in any case to which they are part. That's Article and so on.
But if the judgment of the court was not obeyed, let us say the court forbade the hanging of a person, and the Barbados Privy Council did not recommend commutation, and the government were proceeding to carry out the execution. What would be the position? Would it then be, would the convicted person, the condemned man, be able to require a court to compute on the ground that it was a breach of his right to the protection of the law?
Your Honor, I think that is an area for another day.
You,
But
you're not ready to extend the protection of the law as yet.
I think Your Honor reads me correctly.
Due process will not apply in such a
But we
situation.
do
But
go.
you're going to do it incrementally.
Well, that is what is called, Your Honor, the development of the common law.
With respect, Counsel, all that would happen is the state would engage its international responsibility and would be liable at the international plane only. That is the answer.
Depending on Your Honor's pronouncements in relation to the development of the common law.
Well, I'd better leave it for another day.
I think so.
I am being reminded, Your Honors, that depending on the repercussions internationally, the government of Barbados might prefer to follow the decision as opposed to.
It's coalition.
International auspices.
I have no idea.
But you still did not mention the date.
I should have to find that. I thought it was part of the record. This is it? This is yes, I will find it for your lordship.
Okay.
My lords, sorry, Your Honours, I think I need to mention, of course, the question of the Supreme Law clause that reference has been drawn to. And I need to deal finally with the point that was made by my learned friend in relation to fair hearing. And in that regard, I should like to take Your Honours to the decision of the Court of Appeal of Barbados, which is in volume 1 of the record. I think the submission that was made by my learned friend, Mr. Ford, was that there was a finding of fact that the Barbados Privy Council had been fair. Your Honours, it is my submission that there were arguments presented to the Court of Appeal that represented where the proposition was put that your respondents ought to be given an oral hearing, and there were questions of the funding. The issues outlined by the Court of Appeal are at page 233 of the judgment. In its introduction, where it says it is page 233 of volume 1 of the record, paragraph 1. This appeal raises two main issues. First, whether there's a breach of the appellant's constitutional rights to carry out a death sentence for murder prior to receiving final reports from the human rights bodies, those reports being considered by the Barbados Privy Council. That's the first issue. The second issue was whether the Barbados Privy Council, in deciding on its advice to the Governor-General on the exercise of the prerogative of mercy, complied with the rules of fairness and natural justice. It is that issue which is being, the second issue is the issue which is being addressed by the Court of Appeal at paragraph 40, which is page 264. arguments that were raised under that related to whether your respondents had a right to an oral hearing and to funding. In our submission, it is clear from a reading of the judgment that at paragraph 53, which is at 274, which reads, "We see nothing in the circumstances of the appellant's case that would have required an oral hearing before the BPC. However, we would not exclude the desirability of an oral hearing in all cases and for all times. For as Lord Bingham said in the unanimous Judicial Committee Privy Council decision in Hines, the Constitution is to be read not as a mutable historical document, but as a living instrument reflecting the values of the people of Barbados as they gradually change over time. The appellants conspicuously failed to avail themselves of the opportunity to make written representations to the BPC. Further, the issues about which they complain, such as the difference between their punishment and that of their co-accused, could have been the subject of written representation and was in any event part of the record of the proceedings. We can find no merit in the grounds of appeal discussed under this issue." It is our submission that the Court of Appeal is there disposing of arguments in relation to oral hearing and funding. And then it goes on to consider the house and all it. So we can find no merit in the grounds of appeal discussed under issue 2 is to be seen in light of that fact. I can't quite understand the arguments that were put forward by the Crown, which seem to suggest that there was a fair hearing, even though the court came to the conclusion that the BPC ought to wait.
You are not challenging these findings.
Not in this appeal, Your Honor. No, we are not. No, we are not. The appeal comes before Your Honor's court on the issues as to the effect of the treaty obligations and the other issues that have been argued before, Your Honor.
Mr. Shepherd, might I just ask one thing? You are challenging the right of the respondents to be heard, and I mean heard not orally, but to submit written submissions in relation to the reading of the warrant in 2004.
Yes, Your Honor.
Because it seems that the Court of Appeal only considered the question of oral hearing in relation to the first warrant, 2002. They did not address their minds towards the 2004 reading. I think maybe because the Attorney General had said that that wasn't really a hearing of the BPC. It was to consider the order in council from the Judicial Committee. Therefore, they did not see it necessary to inform the accused that you could make written submissions in relation to that warrant. So do you accept that, or is this one of your contentions, that you are entitled to?
We do not press it in this appeal.
Oh, you don't? Okay. I just wondered.
Just that, please. I did not argue it before the Court of Appeal, and I think I should just take counsel with my union.
But it was his written submission.
I thought so.
Yeah.
I am told, Your Honors, that the argument was in the Court of Appeal that there was a right to hearing on the second one.
Yes. And I thought that point was also pursued in your written submissions.
I ought to speak somewhat to that. At the time when the warrants were read, of course, your respondents took the view that it was inappropriate for the BPC to meet. I think what your respondents said was that if you're going to reprieve, that's fine, please go ahead and do so. But if you're not going to reprieve, you ought not to consider at this time whether or not you are going to issue the warrant in light of the circumstances that prevail at each time, certainly in relation to the petitions. As I understood the matter, the Crown took the position that in line with Pratt and Morgan, they had a duty to sit at the BPC ought to consider the question of commutation immediately after the Court of Appeal had decided on the criminal appeal, and that there need not be any other further hearings. Now, I think that to a large extent, it is my understanding that whether there were any further hearings or reconsiderations and so on is not clear. It was our view at the time that they ought to await. The constitutional motions were then filed on the basis that they ought to wait. And on the basis that they ought to wait, if that point succeeded, then clearly what would happen is that there would be another sitting of the BPC in relation to any recommendations or the positions that were taken. We also, I think, argued that, so we proceeded on the basis that if the motion succeeded, there would be another sitting. If the motions do not, if the appeal does not, if the appeal of the respondent succeeds, and there is, and your Lordship's board accepts, your Honour's board accepts the point that the imposition of the death penalty is academic, then the point doesn't arise.
Why I asked is that within your submissions at page 37, you did raise that point. About 2 years having elapsed since the last hearing, and matters may have arisen since then which were relevant to the question of commutation.
Yes, I'm sorry, Your Honour, we do stand by that. It would be our position in relation, to some extent I'm being bogged down in this because it is academic. It only arises in the event that Your Honours decide to allow the appeal and reimpose the death penalty, the penalty. That is the only occasion on which it would arise.
The question is whether we should give some guidance for the future.
Yeah.
You see, you in your written submissions, you have criticized the BPC for having sat after the Court of Appeal decision and before you went to the Privy Council. Although, as you have just said, that is the course that was really prescribed in Pratt and Morgan. Now, what do you say about that? Is it that we should vary the the order that was proposed in Pratt and Morgan.
I ought to clarify that, Your Honor. It is our submission that Pratt and Morgan, as I recall, decided that the local advisory council ought to meet after the Court of Appeal has decided the case in its criminal jurisdiction. I submit that the proper interpretation on that is that they would meet. If they were going to commute the sentence at that time, obviously it would have an impact in relation to any further conduct of the criminal appeals, because there will be several cases where, as a result of a criminal appeal, the only possible outcome is manslaughter and life. So let us assume that you were convicted of murder and that the Court of Appeal had dismissed that, but the BPC had decided to commute, and the prisoner was aware of that commutation. Then it would save, in some circumstances, I think, further appellate time. If, however, during the course of those deliberations, it became clear that the condemned man was a candidate, as it were, for execution, then it is our submission that, provided the Privy Council were aware of the fact that the appeal against the decision of the Court of Appeal was being prosecuted, it ought not to read the warrant. And that is what we said was the position in the case of your respondents here. In other words, the argument was that, in fact, the reading of the warrants was actually contrary to the rules then existing governing appeals from...
Yes, but the reading of the warrant does not necessarily have to take place as soon as the BPC has dealt with the case. I mean, I agree.
Yes.
I agree with you and Dali, and I speak for myself, that the warrant ought not to be read while there is still an appeal pending to the Privy Council.
Or now to your Honour's court.
Or
now to your Honour's
yes,
court.
or here, yes, of course. But I don't, that doesn't mean to say that the BPC cannot go ahead and do their part of it before the Privy Council appeal is heard.
Except for the fact, Your Honour, that in the event that there was... I accept what Your Honour is saying, except for the fact that we say that at a later stage, when obviously the Crown or the Executive is considering reading the warrant, that reading ought to be preceded and must be preceded by a hearing before the BPC at that time.
What, a second hearing?
Yes.
Why?
Because, for a number of reasons. Firstly, there may be circumstances which have arisen in the interim. And secondly, surely the BPC is to consider any recommendation from the international body.
If available.
If available. But I've already submitted that in terms of Barbados, in the event that the Governor-General does not exercise his powers under the Constitution to issue guidelines, talking of the future, and in the event that the amendment covered everybody in the future, then the argument would be that no delay would be counted, and that therefore, in the absence of guidelines, the Crown ought to await the determination.
And
for the
that
recommendation.
would mean a return of the death row phenomenon.
Well, it would appear that that is what the constitutional amendment allows.
Coupled with Lewis.
Because clearly they have disapplied Pratt and Morgan.
Yes.
One other point, I mean, how many bites, the cherry, so to speak, does the accused get? Are we saying that there's the obvious right after the Court of Appeal have not allowed any appeal, so the BPC must meet then? And then, of course, the case goes to the Privy Council or the CCJ. Surely the BPC should reconsider it in the light of the Privy Council or CCJ judgment, because, of course, there could be very significant features appearing in that particular judgment. But then, if you still have the international process, then there's a third occasion after the report is received from the Human Rights Commission. So, in fact, really there ought to be 3 meetings of the BPC, assuming that it doesn't commute at the first occasion, but it has an occasion to commute after the Court of Appeal case, it has an occasion to commute after the Privy Council or CCJ decision, and then it has an occasion to commute after the Human Rights Commission process is finished.
And at each stage, if it commutes, then obviously it may foreclose the need
exactly,
to meet. But it would foreclose, as soon as if it commutes on the first hearing, that is an end to the matter, or the second hearing, or whatever. But I would submit that in the case of a condemned man, surely the moment you are concerned to issue a warrant, immediately prior to that, there must be a hearing of the BPC. And I think that the point is underscored to a large extent by the fact that, that it has been the experience in Barbados that many cases argued to the Judicial Committee of the Privy Council were argued on points not taken below, were argued against the availability of evidence, and so on. It is all very well, Your Honours, I hope that Your Honours will allow me to say this. The point is that we do have legal aid in Barbados.
We what?
We do have legal aid. And we do have compulsory legal aid for persons who are prosecuted for murder. But the point is that that legal aid can, and sometimes, more often than not, descends on counsel that may be 2 or 3 or 5 years at the bar. And I do say this, that certainly in my experience at the bar, the condemned man had exposure to senior counsel for the first time at the Judicial Committee of the Privy Council stage. And that is the reality. And many of, in fact, my attention was drawn to, I think, some postscript in Lewis, where the Privy Council said some very nice things about English counsel and not some very flattering things about Caribbean.
That was Lord Stein.
Yes, I think so.
Who was not always made complimentary about our judges either. So take heart.
No, but I think, my lords, it is a fact worth noting that in light of the retention of the death penalty, that really the Judicial Committee then process was the first time that the condemned man really had his matter dealt with properly.
Anyway, the respondents in this case cannot claim to have suffered in that regard. They're very fortunate to have had the representation they have.
Your Lordship, sorry, Your Honour, most gracious.
May I ask one question which you are not bound to answer? Why were no representations submitted to the BPC?
Simply because there was an assumption on behalf of counsel that it was a foregone conclusion.
It was what?
A foregone conclusion. And secondly, there was an argument at the time in relation to funding. Now, let me be frank about this, Your Honor. It is my submission, not necessarily shared by other counsel. It is my position that unless counsel are funded properly, you are not going to get proper representation for condemned prisoners. It's not going to happen. And as the bar grows, then obviously you're going to have situations where several members of the bar will do this. Now, if mandatory is to be retained, and if the BPC is to function in a manner in which is addressed in Lewis, then that is the only time and first time in which your condemned man will have an opportunity to mitigate. That mitigation process must necessarily, in most cases, include the gathering of evidence. Maybe for the first time, you would want to have a psychiatric report. Other evidence may be available. It is simply, in my submission, not going to happen unless proper funding is available. And so, the consideration at the time was, first of all, we have a petition, we are proceeding to JCPC. In other words, the Judicial Committee of the Privy Council, you must not read. Secondly, on the second occasion, the position was that you must wait. So we were saying it is inappropriate for you to meet, because what is the point? Unless you're going to commute. If you are going to commute, please do so. But if you're not going to commute, then we have another opportunity, and we would rather take that opportunity after the reports from the international bodies come in. And in relation to that, we were also arguing, which was argued at first instance and before the Court of Appeal, not pressed here, the question of funding. What we were hoping at that time was to possibly gain some sort of ruling from the Barbados Court of Appeal in relation to these issues. Then, when the appeal was successful at the Barbados court level, there was some discussion, obviously, as to whether the matter would be pursued to Your Honour's court. But by and large, the discussion centered around how academic it would be.
But not about funding.
No, we do not press that here. We do not press that here.
But is it that the Barbados bar is so thin that there are not very competent counsel who will do a case for a murder accused at a very nominal fee?
That is absolutely correct.
Well, I thought, I mean, from my own experience, that I think the competence of the Barbados bar generally is beyond question.
That is not, Your Honor, that is not the question, whether the Barbados bar is competent. The question is whether, given the present legal aid system...
No, I'm talking about whether or not there's a legal aid system.
It is not customary in Barbados for silk to lead in defense in murder cases. It is not customary.
Well, that's a different thing.
It does not happen. What happens is that the legal aid actually nominate somebody.
No, but what I was asking you about is whether counsel, junior counsel, perhaps senior junior counsel, would not be available in Barbados to do a murder case.
I'm not saying that he's not
And
available.
at a very nominal fee.
I'm not, my experience has been, in my own case, I was counsel for Roberts and Bradshaw at a stage when I was 5 years at the bar. And I do not consider that I was adequately equipped to defend them on that occasion on a murder charge. I do not. And as it turned out, I later on argued counsel error. But what I think was what disturbed me about the Roberts and Bradshaw case, Your Honours, is the fact that the Valen Court decision in Canada was available at that time, challenging constructive, and I did not pick it up. And there were other issues that I did not pick up. So regardless of how competent you are, if you are going to expose people to a death penalty in circumstances where people of 3, 4, 5, 6, 7 years are defending them, then our best opportunity to ensure some form of fairness for condemned prisoners is really at the mercy stage.
We are going to dispense with the break and continue until hopefully the conclusion.
Unless there is anything further I can assist, Your Honours, that would be the respondent's.
Yes.
There is just one issue, and that is that if Your Honours wished some form of written submissions on the retrospective point, we would be happy to do so in writing after.
Yes, I think that might be helpful. And also the date of the report, if you would make a note of it.
Right.
And we would also invite the appellant, Mr. Ford, to make any submission in writing that you would like with regard to the applicability of the amendments of the Constitution, the 2001 amendment to
2002, Your Honour.
2002.
They came into force in September 2002.
2002, okay, amendment to this case of the amendment of the Constitution to the respondents and to the issues in this case, and we would ask you to let us have that say Friday the 7th of July.
As Your Honours, please.
Yes. Very well. Thank you.
There is actually one other logistics I will ask Your Honours to apologise for my occasional slip, which may have occurred more than I would have wanted in the way in which I addressed Your Honours.
All right. Thank you, Mr. Chairman. Thank you very much. Mr. Ford.
Honours, I must insist on the, I must respectfully request that the break be taken now.
You would like a break? So, all right. How long would you wish?
5 minutes.
Well, let's say 10.
We
resume at 10 to 4.
All right.
Thank you.
Rise to the President and judges of the Supreme Court of Justice.
Yes, Mr. Ford.
Your Honors, I begin on the premise that repetition is not a good argument. So I'll be brief. In relation to the point on the incorporation of treaties, my friend relied heavily of the views of Lord Hoffman in Higgs. But I would remind him that although Lord Hoffman and Higgs, in the case of Higgs, apparently left the position open or with may appear to be ambivalent, Lord Hoffman also appeared in Lewis. And his decision in Lewis is quite clear in relation to the unincorporated treaties. So the reference to Higgs, in my respectful submission, carries us nowhere, where Lord Hoffman is very definitive in Lewis. So what he said prior doesn't really advance the law. It is what he says and his real position in terms of, and what he actually says in Lewis is that the issue was not really confronted. They used the philosopher's stone. I would also say on that issue, and that the common law never recognized that right of treating a petition as an analogous procedure, appellate procedure. It was never part of it. It was not part of the customary common law, and it is not part of the common law. The common law never recognized one's right to petition.
But that is the citizen's right.
The citizen's right. The common law never recognized that. In relation to my friends, the argument in the state accepting the jurisdiction of the international court, I think that issue has been well explained in the case which is cited, R.V. Lyons at paragraph 44. English courts will not, unless expressly so provide, would not be bound to give effect to the interpretations of a treaty by any national court, even though the United Kingdom is bound by international law to do so. So the courts themselves, the English court, our Barbadian courts, are not bound to give effect. The international law binds states. And even though in international law, the states are seen as a unit, what the case is saying, in the domestic law, however, the position is different. The domestic constitution is based on the separation of powers. In domestic law, the courts are obliged to give effect to the law as enacted by Parliament. So the answer to that is found in our Lyons in terms of your international court.
Is there no English decision that goes the other way from Lyons?
Is there?
Is there no English decision that takes the opposite view?
All the decisions I've seen, the English have been consistent in their position that unless a treaty is incorporated, it does not form part of the
No, but in terms of recognizing that international treaties, which were signed and ratified, establish a societal norm, a new societal norm within the jurisdiction. Is there any English case that accepts that proposition?
No.
I'm not familiar with any, but I am.
But have you searched the reports?
Yes, I did. I haven't found any. What I can say is that
so if someone found a case, be surprised.
At what level?
Well, I don't know, at any level. At any level.
Well. I haven't found
But I think I would suggest that there are some cases. I haven't got them to hand, but I would suggest there are some cases.
Which go the other way?
Yes.
The unincorporated treaties form part of the.
No.
Oh.
On the question of whether the signing and ratification of a treaty establishes a societal norm, which the courts would consider as having some effect domestically, municipally.
I would say that goes into the area if there is unanimity and it forms part of your if it forms part of your customary international law, so be it. If there's unanimity on it, I believe if you had a treaty relating to piracy, child abuse, and those areas, ratification itself, because they're part of just Cogans, would form part of the international law. But where there is no unanimity in terms of the international community, as there is in relation to the death penalty, I would say not. And there is not a unanimous position in relation to the death penalty. So the whole question of your customary international law.
Is it significant that 93 countries have signed the optional protocol to allow their citizens access to the United Nations?
I do not. I found that in a particular case. To me, it is not significant. I found that either in Matthews or Rudolph, the fact that a state is entitled to choose its own way of life. And notwithstanding that other nations do act a particular way, you are not so to act. The state is free to choose its own path. Each state, that is the object and the privilege of independence. I need not, if 99% of the world go against the death penalty, I can retain it. That's the right of a state, the right of statehood. There are certain norms in terms of piracy and whatever, but I do not think murder has yet reached that stage. The death penalty has not yet reached that stage. And if it reaches that stage, then it may then fall into the category of customary international law. And then by that, it will be so binding. It will fall out of the category, it will fall into a special category of customary international law, will be so binding. That's why I will seek to explain that in terms of international law. But it has not yet so advanced.
Would you say international law, to some extent, is contract law, but on an international plane? And a fundamental common law rule is a contract between A and B for the benefit of C gives C no rights whatsoever.
Totally agree with that. It's to be called the doctrine of privity, by your recollection of it. In terms of the Section 78, I still maintain that Section 78.3, once the Barbados Privy Council complies with the provisions of Section 78.3, it has acted fairly. And 78.3 says that you shall consider the report of the judge together with such information derived from the record or elsewhere as the Governor General may require. And as I've said this morning, I repeat in this one, the call is the Governor General's call. If it is his call not to require the report from an international body, and that report does not form part of the documents ought to be considered by the BPC. It is the Governor General's call and not the call of the condemned man. He determines whatever other information is so required. Because we are dealing with the exercise of mercy, clemency to which he has no rights. He has a procedure, if there's any right, there's a procedural right. In his procedural right, he cannot determine what the Governor General should examine or what he should not examine. The framers have already determined these are the framers of this Section 3 could have ended at the record. All the BPC need to look at is the record, full stop. If that was the constitutional provision and it was the supreme law of the land, so long as the BPC acted in accordance with it, the process would be fair.
But if you're dismissing a judge, wouldn't you have to have a certain fairness in your procedure? I mean, as in Crane, they didn't specify that at the preliminary stage there should be any hearing of the judge. There should be any natural justice on the decision as to whether to refer the matter to a tribunal of inquiry.
There's a distinction between general fairness and fairness within the meaning of Section 18(a). I think the Mirbucks made that position, that the Belize Privy Council can be fair, but they need not be fair in terms of court fairness. It is not a court or tribunal. So although you can be fair, you need not adhere to the principles under Section 18(a). So the Barbados Privy Council, being not a court or a tribunal so prescribed, need not comply with the provisions of 18(a). It need be fair in its own area of administrative law. It need not be fair. And I put it another way: a tribunal need not apply the principles of 18(a). Where 18(a) relates to tribunals which are determined civil rights and obligations. And if you find yourself outside that category, where you are not determining rights and obligations, then 18(a) does not apply to you. So that has always been, in my case, the difficulty in trying to get into the BPC a breach of Section 18(a). Because the BPC is not bound by 18(a). The Mirbucks case suggests that. In order to be bound by 18(a), you must be a court or a tribunal determining rights and liabilities. So a breach of the natural justice in relation to the BPC is not a breach of Section 18. It is a breach of the Section 78 if there is a breach, and a Section 78 does not give you a 24 remedy. And that has been the submission there. But the point I was making here is that there is nothing in 78.3 which mandates that the Governor General must examine a report.
But if you breach a provision of the Constitution, is a court not entitled to find a remedy for that breach? I mean, what about Mirage and the Attorney General?
Oh, yes, I totally agree that a breach would not go without any relief. But what I am saying, the relief would not be as wide as in Section 24. The relief in this particular case could be to set aside the decision, a nullity, a quash, whatever. But what I am saying in terms of judicial review, the relief is limited, whereas in a breach under the Human Rights Section 12 to 23, it is wide. That's the submission. And that is why it is so wide, it may encompass the commutation of a sentence, which is ordinarily reserved for the Governor General. So what I've argued from the outset is that a breach of the Constitution does not necessarily give you a 24 remedy. But I take the point, yes, if there's a breach of 78, the one proper relief would be a question of the conviction, the decision so made, or compensation or whatever. But it does not lend itself to the wideness of 24, the width of 24. And
so just a minute. You said one possible relief could be compensation. So a situation can arise where, in fact, a condemned man is executed and his heirs are given compensation.
Technically so, if the only breach was a breach, if the breach fell outside of 12 to 23.
The courts then would be powerless.
That's right. So that is why people always seek to bring themselves, and they fight very hard to find themselves in between 12 and 23. Because of the width of the order, the band of the order. And that is why we should be slow And we should have good evidence before we fit them into that bag. We should be loath to fit them into that bag.
Why?
Unless you establish, because of the whiff of the order, unless I'm putting this way, because of the whiff of the orders of 24, unless there is clear evidence of a breach of the particular sections, one should not seek to give that relief.
Is that a liberal, generous interpretation?
I think in terms of, 24, I'll put it this way, the relief under 24 is restrictive. It is not generous. It is restricted to 12 to 23. And it is restrictive because it's far-reaching, in my respectful submission. It says appropriate order. An appropriate order can be such that it can, as in this case, it can be so appropriate that a person can commit murder and do not suffer death. The Constitution says if you commit murder, thou shalt suffer death. But because of the whiff of the provision, we talk about reality now. We're not speaking in the abstract. In reality, the persons would have committed murder, but did not suffer the consequences. That is reality. I was once asked by the court to deal with reality. The reality is that more than 5 years have expired. Another reality is that they have committed death, a murder, and will not die for the offense. Those are the two harsh realities. One is that 5 years have gone, and the second one is they have committed death, committed murder, and the possibility that they shall not die in accordance with it. Those are the harsh realities sometimes.
You know, in this case, there are a number of issues, really quite a few, that have arisen in the course of the case. But the suggestion is that many of them are really largely academic. And I think this is so because, firstly, the fact is that 5 years and 5 months have elapsed. And as you have conceded, there isn't any special circumstance in this case which would rebut the presumption that to execute the respondents now would be cruel and inhuman punishment. And also because of the amendments of the Constitution, which, to use Mr. Shepherd's word, disapply the Pratt and Morgan decision, and also provide a method of mitigating the effects of Lewis, if Lewis is to be followed. I just wondered if you wanted to say anything to us with regard to that issue as to whether we should, how far in our judgment we should confine ourselves to all that it is really necessary to decide in order to determine the fate of these men. How far we should give some guidance for the future, and how far we should express views as to what has now become water under the bridge, so to speak.
I think it is necessary to express a view, particularly in relation to the unincorporated treaties. I don't think it would be sufficient for this court to hold, if it were so minded, that more than 5 years have elapsed, there's a breach of Section 15, end of matter. I think that the issue in relation to the incorporation of treaties and the settlement of the law in that area, the jurisprudence ought to be enriched.
Yes. Yes. Very well. Anything else, Mr. Ford?
No, unless I can be further assistance, I thank you.
That's it?
That's it.
Well, thank you. Thank you, Mr. Ford, for your assistance. About you want to ask? Well, we reserve our judgment, and we'll get it on a date to be announced.
All right.